Honorable Kumalo, good evening. Greetings, Honorable.
Good evening, Chairperson. I'm sorry, and honorable members.
Honorable Van Staden, good evening.
Evening, Chair and members. Nice to hear your voice again.
Honorable Shabangu Tovela.
Honorable Chair, and good evening to other members.
Honorable Dr. Litlape Sawubona.
Sawubona, Chair, and good evening to the members and those in attendance.
Greetings, Honorable Clark. Honorable Chirampungoze Dumela.
Sawubona Sihlalo, greetings to yourself and everybody else. Ngiyabonga.
Honorable Mujadu Sawubona.
Salbona Chairperson, molweni.
Honorable Mutubaze Tovela.
Tovela, Chair.
Whom did I miss? I was trying to check who's in the meeting. Did I miss any other colleague? I'm trying to also check.
Recording in progress.
I can see you, DDG Pule. You are in the meeting. Thus far, the acting DG, you are in the meeting. I can see you, Professor Crisp. We do correct, ne? I want to check that first. Do we form a quorum to start the meeting?
Good afternoon. Yes, Chair, we do. Thank you.
We do correct. Then I should think then we need to start. Can you fly the agenda for us? Thank you, Vuyo, for the agenda. This is how our agenda looks like. We are going to start with the opening remarks, then deal with the issue of attendance and the apologies. Then we are going to ask the minister to update us on the suspension of those senior officials. And then also the minister will also update us on the measure being implemented by the National Health Laboratory Services to prevent the recurrence of system downtime disruptions. Then the National Health Laboratory Services will then make a presentation. We are going to discuss that presentation. And then from there, we are going to get the responses by the Health Professions Council on outstanding issues raised by the committee and any other related matters. Thereafter, we will then discuss that. Post that, then we will have a closing remarks, and we anticipate to be out of here at 25 to 11. So the presenters, those that was gonna be responding, can they assist us that if need be, we can knock off earlier? So can I get a mover and the seconder of this agenda? The hand of Dr. Kaleru.
I'm happy to move that the agenda be adopted, Chair.
There's a mover, a seconder. I see the hand of Honorable Clark.
Thanks, Chair. I second the agenda.
Oh, okay. Having said that, then before I make my opening remarks, can we then get the item on apologies? If there's any, Secretariat?
Thank you, Chair. I've only received one apology from Ms. Mhlongo. Thank you, Chair.
Yes, she's still hospitalized and we wish her a speedy recovery. Welcome, Minister. I see you have since joined.
Chairperson.
Thank you, Chairperson.
Okay,
Chair.
yes.
I'm sorry, Chairperson. I've saw the apology of Honorable Xebo. Yes, in one of our group.
Okay.
Yes.
Okay, it's noted. Okay, then let's then welcome the Minister and the team from DOH. Then let's welcome the team from NHLS and also the team from HPCSA. I think we'll deal with the issue of introductions as and when. Yeah, I think especially for the HPCSA and also for the NHLS. The HPCSA, I understand that there's a new board, that got elected in December. It was post our interactions with them in November. Then, we'll have to deal with that the moment let's start now from the team of the NHLS. Who is in the meeting? Can they quickly introduce themselves and their designations?
Good evening, Honorable Chair Mkambi and the members of the Portfolio Committee. Speaking, it is Professor Kollega Milisana, the CEO of the NHLS, but I do want to just record the apologies from the chair of our board, Professor Mpahlele. He unfortunately has academic functions that he really could not get out of, and he sent his apology. And with me, I have the members of the executive, and maybe should I allow them to introduce themselves very quickly?
Yes.
Good evening, Honorable Chair and Honorable Members. My name is Dr. Sylvia Sateche. I'm the Chief Information Officer for the NHLS. Thank you.
Okay.
Thank you, Chair. Good evening, Honorable Chair, and to the Honorable Members. My name is Pumeza Mayengiso. I am the NHLS CFO. Thank you.
Okay.
Good evening, Honorable Chair and Honorable Members. I'm Professor Peter Meyer. I'm the Executive Manager, Laboratory Service in HLS.
Thank you.
Good evening, Honorable Chair, Honorable Members. I'm Debo Kikal. I'm the Company Secretary for the NHLS. Thank you.
Thank you. Thank you for the introduction. Is there any other person
And
again?
Chair, yes, Chair, we have online our monitoring and evaluation national manager, Ms. Kabashale. She will introduce herself. Thank you.
Can she do that quickly?
Good evening, Honorable Chair and Honorable Members. I'm Violet Khabashani, National Senior Manager for Monitoring and Evaluation, and I'm also supporting the CEO's
We can
office.
see you. We want to see you. Where are you? Are you sleeping? Are you in bed?
No, I'm not in bed. Let me see if I can put the camera on. I don't know. Technology is playing games with me, Chair.
Okay. At some point,
Sorry, Chair. If I get to open the thing, I'll do it.
Okay.
Or here.
Where are you?
Can you see me?
Yes.
That's
You
me.
look, oh, I see.
Yes.
Okay.
Thank you, Chair.
Thank you. Thank you so much. Then can we get the HPCSA to do their own introductions too? Is
Good
the
evening, Honorable Chair and the members. My name is Wezile Chita.
You'll have to sort that volume right away from the beginning because we can't hear you. You'll have to sort it now right from the beginning.
My name is Professor Wezile Chita. I'm the President of the Health Professions Council of South Africa. I will allow the other members to introduce themselves.
Good evening, Honorable Chair. My name is Professor Lundi Shangase. I'm the Vice President of the Council. Thank you.
Good evening, Honorable Chair and Honorable Members. I'm Professor Antluani. I chair the Medical and Dental Board. Thank you.
Good evening, Honorable Chair and Honorable Members. My name is Dr. Kami Chetty. I'm the Interim Registrar of the HPCSA.
Good evening, Honorable Chair and Honorable Members. I'm Gwena Mabasa. I'm the Acting Head of Department, Legal and Regulatory Affairs.
Good evening, Honorable Chair and Honorable Members. I'm Tsikelelo Spega. I am the Company Secretary.
Good evening, Honorable Chair and Honorable Members. I'm Priscilla Sokhonyana, Head of Division Corporate Affairs.
Good evening, Chair and Honorable Members. I'm Melissa de Groof, Chief Financial Officer.
Violet, if you are to continue the way you are continuing, we're going to get you booted out of this meeting. Can you always mute, please? Are you done, HPCSA, with the introductions?
Honorable Chair, we've got Mr. David Mamet here online. He'll introduce himself. Okay, it looks like he hasn't joined us yet.
We're waiting.
Honorable Chair, it looks like he hasn't joined us yet. He will join later on when we're doing our presentation.
Is that the arrangement you made with him?
Can you hear me, Chair? Honorable Chair, can you hear me?
We want to see you too. Not only to hear you.
Yes. Am I visible, Chair?
Yes.
Yes. I'm David Mamita. I'm Head of Department Cooperations at the HPCSA. And thank you very much.
Out of interest, where are you heading to?
Well, I am heading home. I was supposed to have left early so that I could join it properly, but there were delays arising out of the commitments that we had in council.
Provided you don't disrupt our meeting when we need you to respond and you are nowhere to be found.
I certainly will not, Honorable Chair.
Okay. Minister, we are meeting. Do you want to introduce the officials? Because I think we are meeting for the first time in the absence of the DG. Can I hand over to you, Minister?
Thank you very much, Honorable Chair and Honorable Members. Can I go on, Chair?
Yes.
Yes. Let me start by
Whatever you are
extending.
eating seems to be nice.
I was not aware you are going to call me so quick, Chair. I apologize profusely.
Okay, sure.
Yeah. Let me start by extending the apology of the Deputy Minister, Dr. Joe Pat. He won't be able to attend, and I think he has sent in an apology. Chair, as you have already said, I've got a team here headed by the Acting Director General of the department, Professor Nicholas Crisp, who ordinarily is a DDG responsible for NHI. He has been appointed as the acting head of the department for a period of 3 months. He will tell us exactly who he is with. He will introduce the other members. Thank you very much, Prof. Can you introduce your team?
Thank you, Minister. Good evening, Honourable Chair, Honourable Members. With us tonight, we've got, let me see, Anban Pillay, who you know as Deputy Director General, and it's his portfolio that's largely under scrutiny tonight. So thanks very much, Dr. Pillay. Then if I can get Mr.
No, Prof, let them show themselves.
Yeah, Dr. Pillay is on screen. Anban, would you introduce yourself, please? Thank you.
Good evening, Chair, and good evening, honourable members. Anban Pillay from the National Department, DDG for Health Regulations and Compliance.
The same DDG we were with yesterday. Proceed.
Yeah. Thanks very much. And then the next person is Ms. Q Gambo, who is the Head of Corporate Services at the moment, Acting Head of Corporate Services. She's normally the Head of Human Resources. Will you introduce yourself? Q? You are muted. Q, you're still muted. There you go.
I am Karazile Gambu. I'm the acting head of corporate services. Thank you.
Why are you in the dark there? Why are you sitting in the dark?
We can't even see her.
Yeah, we just see a ghost, Chairperson. We are seeing a ghost there in the picture.
Okay,
unless
am I
it is
visible now?
deliberate.
It is not, Chair. My apologies. I can
You
see
still
my
look like a ghost.
goodness. Still.
I think there's a connectivity challenge there. Can we move to Mr. Johannes Gatla? I think everybody's familiar with Joe. Joe, can you show your face, please? Parliamentary Liaison Officer.
It's our regular. Yes,
There we go. Joe, we can't hear or see you at the moment.
We all know you.
Can you see me now, Chair?
No, we don't see you. We can hear you.
We can only hear you, and it's dark there.
Yeah, it's the network. Sorry, Chair. Thank you very much, Chairperson.
Okay, the honourable members are very familiar with Mr. Gatla. We've got the Chief of Staff in the Minister's office is amongst us. I'm just looking for, I think he was here a moment ago. Mr. Mdluli, are you there? Can you introduce yourself, please?
Yes, I'm there, Prof. Good evening, Chair and honourable members, Minister and colleagues.
Thanks, Abham. Thank you very much. We didn't see your picture either, Chief of Staff. I'm not sure why we're missing pictures tonight.
Can you see it now, Prof?
No, it's muted.
No.
It's actually muted. Your video is muted. It's on the screen, but muted.
Yeah, I've unmuted it, Minister.
You are muting. Let's move.
Okay, that's unless I've missed somebody, those are the ones I've seen. Oh, and Advocate Magoshi, Head of Legal Services, Acting Chief Director. If you, yeah.
Good evening, Honorable Chair. Good evening, Minister and honorable members. My name is Rufroma Koshi. I'm the Acting Chief Director of Legal Services. Thank you.
Thank you. Okay, that's everybody that I've seen. Thanks very much, Chair. Honorable Chair.
Okay. Thank you so much, Minister and the team, for the introductions. The members, you will see them as and when they ask questions, but you might have heard me calling their names earlier. So as and when they interact with you, you will see them. Let me take this opportunity to also welcome the delegations as it has introduced itself, and you, Minister, in particular. Tonight, we are convening to exercise our oversight mandate over the critical matters affecting the governance, stability and performance of key institutions within the health sector. As you have seen our agenda, firstly, we are going to receive the update from the Minister on the suspension of the senior officials within the department. I must say up front, this is a matter of serious concern that goes to the heart of the leadership stability, accountability, and administrative integrity. Then there is the committee's expectation for a full clarity on the circumstances surrounding these suspensions, the legal process followed, and the contingency measures in place to ensure that service delivery remains uninterrupted. Secondly, we will engage with the NHLS on their strategy to prevent the recurrence of system failures. These disruptions have directly impacted diagnostic services and patient care, the matter that we are all concerned about. We therefore require some firm assurances regarding the resilience and reliability of the systems underpinning this essential service. Thirdly, we continue with our engagement with the Health Professional Council of South Africa on outstanding issues previously raised by the committee. I must say up front for the new leadership that we've got a concern. We interacted with them in November. We'd asked them to respond to issues as raised by members, but they took time to respond, and it's a matter that we must never condone. And I hope this new leadership will take that into consideration. Because today also it's an opportunity for us to assess that progress, and we want to ensure accountability and determine whether the council is effectively addressing concerns related to governance, regulatory performance, and service to both practitioners and the public. I must say, colleagues, these all issues that we have raised, they are all interconnected. They define a health system that must be transparent, responsive, and have a capable role. So ours tonight is to scrutinize, to hold to account, and to ensure that the corrective actions are both credible and sustained. We are looking forward, as always, to a constructive and transparent engagement with all of you. So that's the issue that we want you to say. If we are then constructive and transparent, then it makes our lives a bit easier. Having said that, Minister, I think you will be able to to introduce all these matters, and thereafter then you will, especially the matter that relates to you with regard to the officials, the other matters on the NHLS, you just introduce them to us. And then also the third matter on the HPCSA, you give us an overview, and then you will hand over to the NHLS to present, and then members will take questions, discuss, then later on we'll go on with the HPCSA. In that order, Minister, over to you.
Thank you very much, Chairperson and honorable members. Honorable members, I've presented a few slides. I am sure about 5 slides to make it easier for you to follow the events. And I'll ask Mr. Khatla to put the slides on the screen. Can you flag the slides, Ndati Khatla? Hello?
Okay, Minister, I'm working on that. Sharing. Okay. There we go.
You seem to be having network challenges, Joe. Yeah, there we go.
Can you put it
no
on
show.
slideshow,
Oh,
please?
okay. Okay.
Yes. Yeah, Chairperson, this is an update on the suspension of the 3 senior officials at the National Department of Health. Can you go to the first slide, please, Joe? Yes. Chairperson, as you may remember, it was on Monday, the 2nd of March this year, when the Director General of the Department of Health, the DDG responsible for hospital and tertiary services and human resources, as well as the Chief Financial Officer, or CFO, were arrested by the Directorate for Priority Crime Investigation, the DPCI, commonly known as the Hawks, and appeared in the Pretoria General Court on the same day on which they were arrested. They were granted bail for 10,000 rand each. And at 16 hours on the same day, the Hawks came to the department and presented me with a charge sheet on which it was written that they must never set foot in the department until their cases have been finalized. Next. On Tuesday, the 3rd of March, that means the following day, I sent my legal advisor, Advocate Ram Mutla, to the court, to the prosecutor's office, to inquire about the actual meaning, because they just said they must never set foot in the department. We did not know whether they mean we can conduct them and ask questions or demand things from them, etc. So that's why Advocate Ram Mutla wanted to find out, because in the charge sheet, it was not very clear. They declined to put this in writing, but told him verbally that this means that they cannot physically report to the department. But I, as the minister, can speak to them if I want to know anything from them, or if I want to, to ask them about anything. But they went on to say, but the other officials in the department must first get the permission of the court if they need to have any form of contact with them. Well, whether by phone or whatever, they must get permission from the court. A situation which obviously is not untenable. So on Wednesday, the following day, I then wrote to the president asking him to give me delegations to suspend the Director General. As you know, that ministers cannot hire, suspend, or fire director, or suspend director generals. It's a prerogative of the president, but the president can delegate. So I had to ask for that delegation. For the other 2 officials, I had the right to suspend them, but I decided not to separate the cases. In other words, I didn't want to separate the other 2 officials who are junior to the DG and leave the DG out. So I waited. And on Friday, the 6th of March, I received the delegations from the president to suspend the Director General. On the same day, Chair, I received a presidential meeting minutes giving me permission to advertise the post of the Director General. Maybe I need to give the background, Chairperson. In January, that was long before this arrest. We did not even know that they are going to be arrested. In January, I wrote to the president asking him to give me this presidential minute that will allow me to advertise the post of the DG, because it is expiring. The contract, rather, is expiring on the 30th of May. And because I can't just advertise without the presidential minute, I wrote to the president in January, because from the beginning of February, we're starting to count the period at which you're supposed to give a notice about suspensions. So that period was starting the 1st of March. So I wrote as early as January because I didn't want to miss the period. And the response came on the same day that I received the response about suspension. Next. Next. Yeah. Because that date, as you can see, was a a weekend, was a Friday evening when I received the two documents. So I waited until Monday morning and I started the PAJA process. You are aware that PAJA insists on audio alteram partem, where you're supposed to ask the person if they can give reasons why they shouldn't be suspended. And so I did that on Monday and gave them 24 hours to respond. On Tuesday, the 10th, the following day, I did receive two responses from the DG and the DG responsible for hospital, tertiary service and HR. I never received any response from the chief financial officer. Be that as it may, in the letters, the audio alteram partem letters, we told them that if they don't respond within that period, we'll still go on. So we then went on, and on Wednesday, the 11th of March, I then issued the letters of suspension to all three of the officials in terms of the labor laws of the country. I then appointed Professor Nicholas Cripps to act as the Director General, as you can see he's doing today. I also appointed two other officials, one to act as the CFO and the other as a DDG, tertiary and hospital services and HR. And finally, on Friday, the 13th of March and Sunday, the 15th of March, we advertised in the national papers the post of Director General and the post of DDG Hospital and Tertiary Service and Human Resources. Maybe I need to explain why the two posts. I've already told you the post of the DG anywhere is coming to an end. His term of office is coming to an end on the 30th of May. The post of the Deputy Director General, Hospital and Tertiary Service and HR is expiring at the end of September, on the 30th of September. Whereas that of the, what you call, and sorry, excuse me, Chairperson, let me start again. The post of DG is expiring on the 30th of May, so that's why we advertised it. But the Deputy Director General for Hospital and Tertiary Services is not on contract, but his pension starts at the end of December. That means he will have turned the pensionable year by that period, and so he will also have to leave. So we thought we could also advertise it. Whereas the post of the CFO, he is not due for any retirement and is not on contract. So his is going to follow the normal processes of the law and the DC processes. Now, at the moment, the departmental internal investigations are ongoing. You are aware, Chair, that we have got 60 days to put charges before them and start the DC process. And we are very much determined not to let the 60 days go by, Chairperson. That's where we are. Thank you very much. But as to the issue of exactly understanding this whole issue of what they were arrested for, we only see on the charge sheet. The Hawks have never told us anything beyond what we see on the chart sheet. Thank you very much.
Thank you. Any clarity seeking questions on the matter, colleagues? I see two hands thus far.
Yeah, boy.
Okay. Honorable Kumalo, mute your microphone, Honorable Kumalo. Okay. Honorable Shira, followed by Honorable Van Staden, then Honorable Clark, Honorable Leroux, and Honorable Mutuvats in that order. Over to you, Honorable Shira.
Thank you so much, Chairperson. Greetings to the Minister once again. Thank you so much, Minister, for the update that you have provided us. Into is pertaining to the issue of the 15 billion rand tender that we had raised the previous time. I know that the Minister was quite forthcoming with the fact that he's open for investigations to happen on that. But this moment really almost feels like, our anxieties were not in vain. And I'm sure the minister will share the sentiments. We were not clutching at straws. And although the minister wasn't the signatory and the DG was, I do want to kindly request that the minister look into this issue once again. There were too many red flags concerning this particular tender, the 15 billion Enainika Ihetro, who was previously cancelled for other issues they had, only for them to come in and then provide business rescue for bars in Innovata. And the various other issues that we raised pertaining to this issue, which I believe the minister recalls from the previous meeting when we were engaging on this particular issue. I know that we had recommended that the SIU look into it, but I think on a political level, as the political head of the department, following these developments, ngiyacela bandla niyifake ilihlo nayo le 15 billion, because we are of the view that the things that happened really probe us in the direction of corruption. And the fact that this then came about shortly after that, also pertaining to HIV medication, leaves very little to be desired. So that is our only request, and I just want to find out if the minister is keen on this particular recommendation. Ngiyabonga Sihlalo.
Okay. Who's next?
Thank you, Chairperson. Sorry for not using my video. I've been struggling with signal this afternoon since the debate. Good evening, Honourable Minister and colleagues from the department. Honourable Minister, thank you for your time to come and visit us tonight. It's really appreciated. I just want to know, first of all, and I've asked these questions before, and then we see things happening in this department. My question again, what I'm going to ask tonight is, can the Minister please inform this committee what necessary steps will he put in place in his department to prevent cases of corruption like this one that is currently before us, to see to it that it don't happen again? Because the reason why I'm asking this is, if you go back on this person who's been suspended now, and if you go back, I know you were not the minister at that time, but it's still the administration, keeps to be the administration. If you go look at the SIU report on the digital vibes on September 21, it was also recommended there that the disciplinary steps be instituted against the same person who had been also at that time suspended as Director General of this department. And I think that report also indicated that he should have faced charges of fraud, corruption, and money laundering at that point. So it looks like it's a phenomenon that's keep repeating himself in this department. But Honourable Minister, I think you need to act, if I can advise you friendly as a colleague and as a friend, and otherwise you're going to get the straps as a political head of this department at the end of the day. Thank you, Honourable Chairperson.
Thank you, Honorable Van Staden. Honorable Clarke.
Thank you, Chairperson. Just proof of life. And then I'll put off because I'm not feeling so great. I've hurt my back. I can hardly walk. But in any case, thank you, Minister, for being here this evening and for presenting this report through to us. Member Van Staden has stolen my thunder, because it is concerning, what the SIU report said in terms of the Digital Vibes contract issue and the implications thereof. So that is one of the very concerning issues. And then, of course, I also just wanted to get clarity from you, Minister. Would the SIU also continue investigating this case? And would we get a report in terms of that investigation? And then I also want to just get clarity whether the DG was also implicated in the oxygen tender that the DPWI is now investigating, but started off with our department, of the Department of Health as well, just to get clarity if there were any implications from that point in terms of that tender as well. Thank you very much.
Honorable Mtovatse, followed by Kumalo.
Is it not me first, Chair? Sorry, apologies.
Apologies, my apologies, Honorable Clerk. Sorry, Honorable Eliro, you can proceed.
Thank you very much, Chair, and thank you to the Minister for coming to share what has been happening in his department, and for bringing us into his conference around those issues, which I think
Yeah,
obviously.
just remind me on the
Yes.
what you call.
Minister in the meeting, or you have unmuted. Mute. Can you ask the minister to mute himself?
Thank you, Chair. Can I continue?
Continue. Yes.
Thank you. So the first question I wanted to ask, I understand that the CFO suspension process is a different process to the two contracted members of his team, but what he said the normal processes apply, but it would be useful to know what that exactly means. What are the timelines we have on the disciplinary process of the Chief Financial Officer, and when can we expect a disciplinary verdict there? We know the public is concerned when people are suspended on full pay, and so it would be helpful to get a timeline when we expect the disciplinary hearings to have concluded and findings to have been made, whether there is guilt or not from the HR perspective. The second question I wanted to ask was just in terms of, I'm glad to hear, Ministers, thank you again for sharing with us that Professor Crisp has been appointed as acting DG, and the two other members of his team have been put into those posts, the CFO post and the DDG posts, in acting positions. But I just wanted to get a sense from the Minister. Of course, this will have an impact on his team and the work that they're doing. How big has that impact been? Is there any way that this can be mitigated further? Thank you very much.
Thank you so much, Honorable Eliro. Now it's Honorable Mutuvatse. You'll be followed by Honorable Komalo, then Honorable Dr. Lekape. In that order.
No, thanks very much. I'm back home. I'm not in Cape Town. I'm having load reduction, as it is called these days. So I'm struggling. Pardon me. Chair, with developments that are happening all over, I couldn't but wonder to remember the former Minister Zola Skweyiya with his Batopele principles, which were aimed at improving service delivery and people-centered, governance. Just generally, I wish I could actually go to his grave and ask him to come and talk to public servants generally in this country, because we are really bleeding. And I would earnestly ask colleagues in the state institutions all over, maybe if they can hear our voice, that they must help us. And the political leadership must help us. And following on what colleagues are saying, the political leadership, no matter what views they have on what we are raising, I think they must help us also not to be in denial, given the current situation that the country is going through. That's a plea that I want to make, and I want to make it to the Minister of Health to help us in this regard. I think it will assist us. We hear things, we're having stories in the departments, especially at the provincial level, with high level of corruption. We can't touch it. People know it is there in the procurement departments, in hospitals, at the provincial levels. It is there. I think we must put our heads together and find a solution to this corruption. that is taking place in the Department of Health. Not only in the Department of Health, but because we are now focusing on the Department of Health. I think, Minister, I want to implore you that we must put our heads together and try and find, if we have to go and ferret, go deeper into the provinces, go deeper into, and you must not mask any difficulties. It might be painful, but we must not mask those difficulties. We must confront them head on. We are having problems. Having said that, Chairperson, I just want to, I might have missed a point where the minister was naming who are the people who have replaced maybe the CFO, and in that order. I think I got one name of someone who's there. Now, with regard to and I'm happy the minister is saying we are not going to wait for 60 days as prescribed by the law. What is the anticipated time? I know that there's still going to be investigations and all this. What is the anticipated time of this whole issue being put together, and then we can get tangible results? And also, what happens? What happens if at the end of the day, hypothetically speaking, that the outside process does not find the culprits guilty? What happens to the process that has been initiated within the department? Because I know for sure that the mistake that happens in most cases is that because the process that is outside has perhaps maybe cleared the culprits, normally people would come back into the labor environment and say, no, given that, therefore, and it doesn't work like this. So I just want to caution the minister and have clarity around that particular matter, that the two must be seen to be separate processes that are unfolding, and the other has no bearing on the other. If the minister can just clarify if that is the same understanding that we are having. And also, what happens now that the DG period was to end now in May? Now, what happens if the processes are still unfolding and his term ends? What happens because normally it will be issues of the pensions and the likes whilst this process is unfolding. Just to get the clarity on those matters, Chairperson. Thanks very much.
Okay. Honorable Kumalo, over to you.
Thank you very much, Chairperson. Chair, let me appreciate the Minister by updating us on the cases of the department. But I'm just having only two questions, Chairperson, which is very quick. One, Chair, I want just to check to the Minister with what is happening with the other officials that are sitting in the supply chain committees of the department, if there is any. Because I think if there are procurement supply chain committees must fit, what is happening with those officials, department heads. And also, Chair, lastly, I want just to request the Minister that they must push the issue of the internal disciplinary hearing before the end of May. He has indicated that the other official contract is ending at the end of May. He can't just go free sport. He must face the internal disciplinary hearing so that he does not go out again to make up with other departments. Thank you, Chair.
Thank you, Honorable Kumalo. Can I recognize Honorable Dr. Hosili Tape?
Thank you, Chair. I'll just provide proof of life for a few seconds that I'm not a robot. Good evening to everyone, and good evening to the Minister, to the DG, and the team. My questions, Minister, are questions of reforms that may be necessary going forward. I just have a problem with ministers not having the ability to take action against their DGs. This arrangement that DGs are appointed by the president and the ministers are appointed by the president creates governance challenges. So would it be something that the minister might agree with, that we need to rearrange those governance structures so that the president continues to appoint his cabinet? DGs must be appointed by the Public Service Commission together with the relevant minister, so that in terms of any disciplinary action, etc., it can be done by the minister. So that when a president appoints a minister, that should come with automatic delegation of the powers to employ or discipline a DG, because otherwise it creates problems. And that's why we have these challenges in governance, where we need political reconfigurations and ensuring that public servants are appointed based on criteria from the Public Service Commission with concurrence of the relevant minister. For me, that's my only question for now, because it would lead to accountability. And what I would also want to ask is, how do we ensure that as Parliament, we are able to hold the minister accountable on issues of procurement? And by that, I mean, how do we get our minister to be close to the procurement phase so that it can't be a distance, that's procurement? I'm not saying a minister must interfere with procurement, but a minister should be able to know and provide answers to Parliament or to the relevant committee on issues of procurement, like the oxygen tender thing. How do we ensure that the minister take responsibility in their own unit, even for procurement issues? Thank you, Chair.
Thank you, colleagues. I think I'd recognize everyone who wanted to speak on these matters. Minister, over to you.
Thank you very much, Chairperson. Thank you, honorable members, and for the question. The first question from Honorable Chiro, whether the minister is keen to investigate everything. Maybe I misunderstood, Chair. Firstly, I am not against. If you remember, in the last meeting where this matter was ventilated, I said I'll hear from you whether you want to call the SIU or to do a different investigation. I'll hear from the committee. I haven't yet heard, but on our side, remember, we are going on to find the facts, because there are court cases about this. This matter is going to appear in court. But if honorable members have got a recommendation that they must make, which come from the committee, we do not have a problem with that. But the court cases are separate. You are aware that after we met, CIPLA put their own court case, which is obviously going to be enrolled by the courts. Honorable Van Staden, measures that must be taken to prevent this issue. Honorable members, all we need to do is to strengthen the PFMA, which is very clear, but people just go against it. But also to make sure that every time there's an outfall like this, there is consequence management but also to make sure, as Treasury is doing after after the SIU report, even the SIU recommended that we do e-procurement so that you pick up distance. It happened as in the case of Tembisa Hospital, where it's believed that if there was e-procurement, somebody would have detected these things earlier on. And that's the process that we're going on with. And yesterday in cabinet, we got 2 reports, one from the public protector and one from the Auditor General herself, also recommending similar issues for the whole government, that the system of e-procurement will immediately improve the situation, because both offices were having a problem with the fact that they are basically post-mortem offices, meaning something happens first and they discover it. We need prevention. As you know, prevention is better than cure. And it is agreed that there will be that. In the hospitals, we are working on what we call business centers, whereby you divide the hospital into smaller groups and each one get their budget and you put a person in charge there, such that if there's going to be any corruption, you must be able to pinpoint it, unlike the present situation where all the procurement is now being done in the is now where all the procurement is done in the provincial department. Chair, can you still hear me? It looks like my things are freezing here.
I can hear you,
Yes, we
Minister.
can hear you, Minister.
Okay, thank you very much. Yeah. The other question is from, from Honorable Van Staden. It's about the digital vibes that the DG who has been arrested was also implicated in the digital vibes, and the SIU report was damning. Honorable members, you may remember that the SIU recommended a DC process. And in terms of the rules, as we've already said, the minister then could not carry out that DC process. It had to be carried to the presidency. This rule or procedure that Honorable Letlape said you must change. The president appointed Judge Cynthia Pretorius to conduct these DC hearings. And it is the judge, as a retired judge really, not in a court of law, but as a judge that must head, must chair the DC. He's the one who released the DG, and that's why he was able to come back to work. This issue of judges, chairperson, we recommended it because we had discovered that in the DC process, when you put a public servant, they usually do each other's favors. You know, it's something like, I'm scratching your back today, tomorrow you'll scratch mine. So we said retired judges must come in to help, because they'll come as neutral arbiters like in the court of law. And in this case, it happened but Judge Cynthia Pretorius released the person. Honorable Michel de Klerk about 002 tender, whether the DG was implicated. Honorable members may also remember that this was a tender carried on by IDT, if you remember. An IDT report to Minister McPherson, the Minister of Public Works. I sat with Minister McPherson. We even took the matter to the president and agreed in front of him that this matter must be investigated right up to the end. And because IDT report to him, to Minister McPherson, he's the one who will carry on the investigation and give us the recommendations. And I promised him that we'll accept all recommendations. Minister McPherson chose PwC PricewaterhouseCoopers, an auditing company. They did this investigation. They did interview the DG. From what I hear, I was told that they did interview him, but then they put no recommendation about what is the finding about him and what they are going to do. All the allegations that were there were in the newspapers all over, especially News 24. They were following up the matter and reporting all the time that was happening. Honorable members may also remember that Minister McPherson, answering a question in Parliament on this issue, said that his understanding was that PwC can only investigate members of the bid adjudication committee who belong to IDT, not those who belong to health, because he argued that he is not responsible for health. I then went to him immediately and said, Minister, I think something went wrong here. Maybe there was miscommunication. If the bid adjudication committee consists of 10 people, they all agree to give a bid to somebody, and we investigate part of them because they come from a different institution, and the other part coming from another institution, we leave them out, whereas they took a similar decision on a similar matter. It's a bit problematic. I then told him that I am not eager or very keen to appoint another investigating institution to come and investigate the people in health, including the DG, because what if they come to a completely different conclusion to the one PwC has reached? And I said, even in the court of law, that is avoided. So I asked him if he can ask PwC to come back, and this time we give them in writing that they must now investigating the other people from health who they left out when they were investigating people from IDT. Minister McPherson agreed, and he said he will have to extend their mandate, which he did following legal channels. It did, of course, take a long time because I used to phone him and ask him how far he is, but he eventually did it. And in February, early in February, the PwC team came to meet me to agree on the parameters of this investigation. What is that which we are expecting? How should they do it? And of course, we told them that they investigate, starting with the DG to any other person in health who was involved in this, and give us a report. That's where we are at the moment. We believe PwC is busy with this work. Chairperson, Honorable Carl Leroux, the DC hearings, we can just promise, Chairperson, that will make it them as much as possible. We won't wait for the 60 days. We are just saying the 60 days is the legal limit, beyond which then the person must come back. We'll try our best to avoid that, but I really can't give any date on which it will start, because it will depend on the people who are carrying on the DGs and whatever is that which they are investigating. The issue of impact, yes, Chairperson, if you lose 3 senior people and you have got to pick junior ones to go up and act, and very clearly there will be a gap. There will be a gap somewhere, and there will be an impact in the department. But we said we'll try our best that the impact is mitigated by making sure that we do everything that could be done to win. Those who understand soccer, there are times when a team left with only 10 players actually win the match just by sheer determination and hard work. But it can be very difficult, like it happened a few days ago. I don't want to name the clubs, but you know what happened a few days ago in the Betway Premier League, where one club was left with 10 players and they were annihilated. But there are times when even with 10 players, a match is won, and we still believe we can hold on. Honorable Mutubati.
I thought you were talking about pirates.
I never said so. Chairperson, please protect me. I never
So,
mentioned
Minister,
pirates.
I have to. You are protected.
Yes, Chairperson, the issue of denial, there's no way we can be in denial, Honorable Mutubats. Remember, when there is corruption in health, I, as the executing authority, and the whole country, people who received health care from the public health, they suffer. So there's no way we can be in denial on behalf of individuals. For what reason? What will we be gaining? Like I'm here now in front of you, having to account for things that I knew nothing about, but as the executing authority, I have to account. I don't enjoy it, Honorable Mutuwatsi, at all. And so there's no way I'll ever defend anybody. I wouldn't know for whatever reason, because it makes me angry to be called and have to account for the deeds of other people. The issues of rumors that we hear, please do inform us, Honorable Mutuwatsi, if there are rumors anywhere in the country, because then we can call the law enforcement agencies and we can't mask any difficulties, I promise. The people who is acting on behalf of the CFO and DDG, I'll leave that to Professor Crisp to give you the names. Now, the issue of what if the courts do not find them guilty, and Honorable Mutubasi is requesting that these processes must be separated. Honorable Mutubasi, I have always known them to be separate processes. I've known them to be like that. I know in the Department of Home Affairs, even after I've left, there are people who we have fired, but the law enforcement agencies have not even come to start with charging them. Just to give you a very popular example, when I left Home Affairs, after discovering that Bushiri and Omotoso got permanent residence documents that were acquired fraudulently, 4 officials were charged. One of them a chief director, the others just junior officials in there. But they were all charged and dismissed from Home Affairs long before I left. But the matters have also been reported to the police, to the Hawks. And up to now, the Hawks have not done anything. We do not know after they've completed what will happen in court. But those people have not been with the department, if I'm not mistaken, for the past 3 years. So yes, I've always known them to be separate. The other example I can give was an official who was posted to our embassy in Namibia, who was selling visas to Pakistani nationals to come into the country illegally, but using visas that purport to be illegal. We took that lady for DC, and of course they prevaricate, they always come with doctor's letters, etc., until we finally said, eventually we put the date, whether she comes or not, we'll charge her and dismiss her, which happened. She never attended that DC. We charged her in absentia and dismissed her and reported the matter to the Hawks. We were made to hear that the night before the Hawks arrested her, she died mysteriously. We still don't know. We left the matter to the Hawks, but she was long gone in the department when that happened. So I'm trying to say we always regard the two processes as separate. What I do not know is if we have already dismissed a person and they go to court, the court say they are not guilty. I've never come upon such a situation. I do not know, honorable members. I will have to go and get the legal advice, especially from labor experts and lawyers. The issue of what happens if it is the end of term comes. The suspension letters for the 2 officials, because we know one is retiring, the other, the term is coming to an end. The letter of suspension stated, as we wrote it, that you are on suspension until your case comes to an end or until your contract comes to an end, whichever comes first. That's what we have written for both of them. In other words, if what comes first is the end of their contract. You can't keep them. Actually, honorable members, the DG wrote me a letter before I wrote the audio alteram partem letter, for which I mentioned the date here. He wrote me a letter that he wants to be released before the end of his contract, before his contract comes to an end, but be paid for the remaining months, which we declined, we rejected and said, no, we cannot do that. We don't know what law we'll be using, because when you settle and start paying remaining contract, it means as a state you are guilty for something or you are making out of court settlement. We never accepted that. So we said it will go on in terms of what is written in the letter of suspension, that they will remain on suspension until the cases come to an end or the contract comes to an end, whichever comes first. But remember that the court cases don't come to an end, even if you are no longer working for the state, as I've already said, and the courts will have a final say. The Honorable Kumalo say we must make sure that the DC takes place before the end of the contract. We'll try our best within the rules, Honorable Member. Honorable Dr. Letlape, yes, I think this matter is being looked at, but it's not just an arrangement, Honorable Letlape. It's actually a court case. You may remember that there was a professor, oh my God, Professor, I don't know why I'm forgetting them now that I'm speaking to you, who was the chairperson, you might remember her, you once worked with her, who was in Home Affairs.
Former minister.
Yes, former minister.
Professor Tlengiwe Mkhize.
Yes, thank you. I don't know why she just disappeared from my memory. Yes, Professor Tlengiwe Mkhize had a DG, not DDG, DG called Apleni in Home Affairs, who she was charging for whatever Apleni had done, and she put the charges herself. Mr. Apleni went to court, and the judge ruled that the DG has got no right to do something like that. It can only be done by the president. And so he dismissed the charges of Professor Tlengiwe Mkhize and reinstated Mr. Apleni back to the work. The cabinet met about this issue because it was causing confusion. Then the conclusion reached was that it's going to be very difficult for the president to go on charging DGs and interviewing them and employing them. Then it was agreed that the president will delegate, and he will delegate to a particular minister outside that department. That means he will delegate to the minister in that department to do the what you call to do the suspension. But for the hearing and the DC, then the president will delegate a different minister altogether to do that job. So we will follow it that way, but it's a court case. It's because of a court ruling, Honorable Tlapi. It was not the arrangement. When Professor Tlengiwe Mkhize did that, her understanding and all our understanding is that whereas we know in the Constitution, the president hires DGs and the premier hires HODs in provinces, we have always thought then that after they were hired, the executing authority they report to can actually take them to DC, suspend them and fire them. And the court said, no, it's not like that. It has to be the president. That's why I had to write him a letter to ask for the delegations. The issue of coming nearer to procurement issues, Honorable Letlape, yes, I've asked that question. I've never got answers. I've asked them from even the Auditor General, because why I did ask, because when I was in Home Affairs, I was charged to pay personal cost on a matter which I knew nothing about. And I had to write a lengthy affidavit to the then Chief Justice Zondo. His ruling, which came out, was that, yes, he accepted that I was not responsible for this. I did not know anything about it, but ministers are responsible for the actions of their officials. That's what the judgment said. I even took it to the cabinet because it's problematic. If you are responsible for somebody's actions, then you must be able to stop that person from doing wrong actions, which means then you must know exactly every step they are taking, whether it won't put you in trouble. But you also know this is a conundrum in the state. If you do that, they say it is a political interference. Even this afternoon, Chair, I listened to the Auditor General on SAFM. She repeated that when they were asking what will make clean audits, what's your recommendation to ministers and department about clean audit. One of the things she said is, if the accounting officer, who's the head of department, is allowed to do their work alone without interference from the political authorities, then things will go right. That statement also hit me because I understand what it means. That it means I can't go and intervene, but if the person done something wrong, I'm suddenly responsible. This matter has not yet been resolved. I am putting it in front of the cabinet every day, Honorable Letlapi. At what stage do ministers as politicians get involved? At what stage do they put an arm's length, as I'm doing? I'm very much afraid of tenders, honorable members. I always put an arm's length between myself and tenders. So as members of parliament, maybe you must also enter this fray, because I can tell you it's a conundrum within the state. Thank you very much, Honorable Chair.
Thank you so much, Honorable Minister. Is that a follow-up, Honorable Clark?
Sorry, Chair, yes, there was just one issue that I omitted. I just wanted to know the 3 individuals that have been suspended, are they suspended with full pay? And what are their annual salary packages? And then I also just want to ask the Minister, once PwC has done the investigation on the oxygen tender relating the Department of Health, whether we as a committee would receive that report. And Chairperson, I would recommend that us as the committee do a recommendation that the SIU also investigate this matter. Thank you very much.
Honorable Mtubatse.
No, thanks. Just a small thing. When the minister was talking about the end of term with the disciplinary hearing, in terms of what they've written to members who have been suspended, because it sounds like, for example, the DDG's term ends in May, on the 30th of May. They've refused to release him because these processes are ongoing. Internally within the department, what does that mean? Does it mean that as investigations go on, you target in 30 days? We are now in April, May it comes to an end, then there's nothing that we can do. Then it brings the whole process to an end internally, because this person is now gone. Now, what would be the interest of us going into this exercise? Just clarify that legally. What does that mean?
Minister, before you come in also, I think I want to comment so that it can also assist the process. You know, with regard to DC matters and criminal matters, on DC matters, it's on a balance of probabilities. On criminal matters, you have to prove beyond reasonable doubt. So in essence, what we have done, Minister, because these colleagues have been arrested and their bail conditions didn't allow them to be in the department, by virtue of them being under police custody, whereas they are released, they've been arrested. So I think we need to commend you for having acted swiftly, because the mere fact that you went through the process of getting permission from the president to suspend the DG and also to suspend the other two officials that are within your delegation and authority, sorry. It's a sign that you understand these principles on the balance of on the burdens of proof, balance of probabilities and beyond reasonable doubt. So I should think on that matter, Minister. That's why I said you have acted swiftly. And there's a matter on that Dr. Leroux that you have not yet responded to, with regard to that permanent employee, wherein you mention of a separate process. That's the issue that I wanted you to also comment on that. And then also then, Minister, there's a comment that the issue that I want you to also comment on. We all know that our health system is federal, because you know yourself that you're not in charge of provinces. I'm also trying to talk to the issues as raised by Honorable Chairperson. The departments in provinces, the Department of Health in provinces are all autonomous. And what you do, Minister, you just share the Minimac meeting. And it's like, maybe to deal with the issue of the norms of standard. But then the systematic corruption can't only be dealt only with by the provinces. So the case in point that I'm trying to raise and share with you with regard to the system, Minister, healthcare professionals are hired also by the provinces, not National Department of Health. And then I think that's the matter which we also need to look at our constitution. Dr. Detlapes was saying it's good. The constitution is good, but not good for administration, as you have rightfully indicated with that court judgment of the then DG of Home Affairs and the late Minister Professor Mkhize, may her soul rest in peace. It created a situation wherein then a DG is so untouchable. It's only the president that can act. So I just wanted to comment also to also try to assist on these issues, Minister, but you can respond. Over to you, Minister.
Thank you very much, Honorable Chair and Honorable Members. Yeah, I presume, Honorable Clerk, that the report from PwC will be made public, unless I'm wrong, but I don't see any reason why it shouldn't. Maybe I'll be advised, but I personally don't find any reason why it shouldn't go public. The issue of suspension, yes, unfortunately, Honorable Clerk, according to the laws of the country, when you put a person on precautionary suspension, it's always on full pay. I wish it was otherwise, because I personally have always not been happy about this, but these are the laws of the country. It's always on full pay. And my suspicion is that's why to take people for DC is a mammoth of a task, because they keep on postponing. I again, when I was in Home Affairs, there was a case which took us 3 years, because the person was coming always with 2 senior counsels for DC, and they will find a way to postpone and then tell us that they are busy in other courts. They postpone for 3 months, they come back, find another reason. So I think these are the laws in the country that ought to be reviewed, because they are really making life very difficult for those of us who have to take responsibility. So yes, unfortunately, it's on full pay. Honorable Mutubatse, I am unable to answer your question without checking experts in the labor field. What will happen if you are charging somebody and in the middle of your DC, before it comes to an end, their contract comes to an end and they have to go, because you can't hold them back once the contract has come to an end. I do not know what the law provides for. Otherwise, I'm going to mislead and lie to you. We will have to consult and see what happens. but I do know cases of people who, before they are charged, when they realize that information is being gathered so that they are going to be charged, they resign immediately and leave the department. And then next time they appear in another department, because on their form, which they fill in for their the job application, where they say any previous convictions, they write no, because indeed they were never convicted of anything. They never went to DC. They jumped before the DC happened. And in terms of the law, you can't do anything. I found it also very problematic. And some of us have reported this matter to the Public Service Commission to relook at it, because it's a very, it reverses our progress in terms of holding people accountable. Honorable Chair, yes, the issues you have mentioned are extremely important. And I must report to this committee that early in February, when the president was evaluating ministers, because he took the job of him and the deputy president evaluating us according to the contract we have signed, I mentioned this issue and say, President, you are evaluating me and holding me responsible on the basis of things for which I do not have authority. The authority lies somewhere, and I am only taking the responsibility. Like you are aware, honorable members, when in the Free State, a person who was convicted was hired, the picture in the newspapers was mine. And yet there is no minister who has got any authority to hire anybody in any province or even to fire them. Now, because of this conundrum, honorable members, in 2017, I put together a team of people who started in this democracy, who have got experience on the running of government, perhaps in the previous era and in the new era. It was chaired by Professor Green Thompson, who was the first HOD in KwaZulu-Natal. During my time, Dr. Letatu will know him very well. He was a professor of obstetrics and gynecology. And then I also put in Professor Greg Hausen, who is extremely experienced public servant, the longest serving I know, because he served as the HOD of health in the Western Cape for 19 full years. And then I called Ralph Mukijima, who was the first HOD in Gauteng. I put them together with a gentleman called Alf Karim. He's a specialist in procurement issues, and a lady called Nomvua Magawa, who is a consultant in the Department of Finance. I gave them a list of 100 hospitals that are always in the news for all the wrong reasons. I said, please visit these hospitals as people who once ran this system. Tell me what is wrong and what is that which I need to do for the hospitals to get out of this trouble. They visited 25 hospitals and asked for a meeting with me. And in the meeting, they said, Minister, we no longer continue with this project. It's a waste of time. I said, how so? They said, because all the problems we found in those hospitals have got nothing to do with the hospitals. They are in the provincial governments. If you want to fix, go there. Now I ask them, what is that which is happening in provincial governments that is causing this problem? They said there are 4 important things. One is HR. They say the HR problems are quite severe. Hiring wrong people in wrong places, doing wrong practices, hiring fewer people and not giving delegations, putting a CFO and let them go on without delegations, etc. They mentioned those things, honorable members, about HR. Now, I got very frustrated because many people and many of you here believe health is a concurrent competency. I'm here to inform you, HR is not concurrent, honorable members. It's a pure provincial function. And many people don't know that even senior doctors and senior administrators, when they are fired in the province and they appeal to the MEC, if the MEC doesn't agree with them, they appeal to me. Legally, I've got no entry point in the laws of South Africa. When you are fired as an employee in a province, you appeal to the MEC. If it doesn't agree with you, you go to CCMA. If they don't agree with you, you go to Labor Court. If they don't agree with you, you go to Labor Appeals Court. It ends there. There's no legal entry for the minister, except if the MEC is prepared to listen and you advise on how to handle the case, which sometimes usually is a very difficult thing. So HR is a function that is purely provincial and it's not concurrent as people think. The second thing they mention is maintenance of buildings, which unfortunately is also not a concurrent function. There are hospitals that can be built nationally, the central hospitals, but all the hospitals are built within provinces. They are the ones who are in charge. They are the ones who issue tenders, and it's not concurrent. The third one is financial management. It is also not concurrent, especially if the money is equitable share. You are aware that equitable share is controlled in the province. In fact, the person who has got more power on these functions than a minister is the premier of that province. He can reprimand the MEC about hiring a wrong person, which is what I did in the Free State. I referred the matter to the premier, because if I stood up and say MEC XYZ, he may listen or he may not listen to me. It's just an advice. It doesn't come with any authority. The last is procurement. Procurement matters unless Treasury rise to us and say they want this to be transversal, to be done at national level, also with them. Otherwise, procurement matters are provincial. That's what happened in Tembisa. So these four things, if we do not resolve them as a country, they are going to eat us alive. Unfortunately, they are there. We are trying at the present moment, honorable members, to advise provinces, for instance, on HR to give delegations. Because you find a situation where a person is a CEO of a hospital, they don't even have a delegation to change what you call to change a window that has been broken to put a new glass, or when the ceiling is falling, and that is very frustrating. So this is because of these honorable members. So Honorable Letlape, it is just like that, and Honorable Chairperson, we think these matters must change, and some of us have started processes to make sure that these things are looked at by the state and change them. Thank you very much.
Thank you, Minister, for such a mouthful response. Maybe to quickly assist on the matter with regard to the person whom you discipline, and then the contract comes to an end. The moment the contracts come to an end, I'm doing it through the experience of my other life. I've been doing this. So when the contract comes to an end and you are busy disciplining a person, then the person starts not to become your employee. They say, what is the definition of an employee? There's case law to that effect, then that relationship ceases. Then if you can continue to discipline that person, he can come and say, you lack jurisdiction because I'm no longer an employee. That's the harshest reality of these things, colleague. The other issues that Minister is saying, I should think like you are saying that fortunately on these matters, if we were to implement the NHI Act, it won't work with these issues that I've raised, Minister. And then I'm glad that you are saying you've started setting some things at government level. But I think it's time, Minister, wherein we need also to look at the Health Act, because certain things are there, but there are those that are constitutional issues that will maybe somebody must sponsor it to the joint constitutional and review committee. But those ones that needs the amendment of the Act, Minister, I should think it's time. It's time, because if you don't then make sure that the Act gets amended, you'll always have these challenges. So this matters, colleagues, is still, you want to respond? If you want, I'm gonna, this matter, but before you do that, these matters are ongoing, colleagues. We'll keep on iterating on the matter, and we expect the minister to update us on the progress as these cases proceed. And together with the other recommendation, I think at the end of this meeting, the issues raised by Honorable Shirwa, let's go and revisit our minutes. We adopted that minutes to say what was the decision. If it's not there, we can look at that and then advise the minister accordingly. Over to you, Minister, on the parting shot on this item so that we move to the next item.
Just a small thing, Chair. Quite a number of these frustrations I've mentioned won't happen under NHI because we're aware, as a new act, we've put them. But now we're in court. Some of the issues on which have been taken to court, they say we want to usurp provincial powers. For instance, on the issue of procurement, how it must be done by people who are in the board, etc., away from provinces, and even an arm's length away from the minister and officials in the department. But we have been told and we hear what the judges say. So we've been trying to change them. But secondly, you remember that in the NHI, certain laws are appealed immediately when NHI becomes law. Certain areas are appealed that are looking into this issue. One example I can give without wasting your time, honorable members, is the issue of life is the many. It happened because of the National Health Act, which was passed in 2003, where the powers of the president and the powers of the minister in dealing with mental health care users were taken away in the new act and given over to the provinces. And that's why the province was able to do what led to a disaster. The health ombudsman said we must reverse that, but it was not reversed individually. It was put as one of the areas which will be repealed once the NHI Act is passed. So, Chairperson, we are still waiting to see what will happen. Thank you.
I hope you meant repealed, not appealed, ne?
Repealed.
Yes,
repeal.
not appealed. Thank you, Minister.
No,
Honorable Mutuvatse.
Repeal, yes.
Chair, is it my understanding that the minister is saying, given all the frustrations and the experience that we have, he is working on repealing the current act, moving into the direction that says we need now to have a bill that would then centralize health to make health to be a national department and not to be an autonomous department. I would suggest, Chairperson, that we agree with the minister. Put aside what I'm saying as the latter part, but we would want to have a bill that comes in front of this committee. We start dealing with this process so that we assist in these matters. That is my appeal. And if we agree, I think processes must be put in motions towards that logical conclusion so that we now centralize the Department of Health. Because in our view, the National Health Insurance will not see the sun of day if we're still having this situation. Thanks, Chair.
Minister, you want to quickly respond to this?
Unfortunately, the issues he's mentioning are in the Constitution, not in the National Health Act. It's the Constitution of the country, unfortunately. Thank you.
That's why I was saying maybe these are the matters I'll implore the colleagues to approach. There's a committee in Parliament that annually reviews the Constitution. So the window is going to open up to the end of May. I think these are the matters, colleagues, we need to sponsor if we had, because honestly, these are some of the matters that we need to sponsor there on the constitutional reviews. Okay. I think we are done on this item. NHLS.
Yeah, Honorable.
You want to do a preview first, Minister?
Yeah,
on
I'm just
NHLS. Sorry, before that, Dr. Liru, sorry about that. I saw your hand later.
Thank you, Chair. I just wanted to raise just a point on the program. We have taken quite a lot longer to respond and to deal with the issue of the update from the minister, and so we're nearly an hour and 20 minutes later than expected for the NHLS to be doing its presentation. I'm just concerned that the Health Professions Council responses will be pushed out to very late, and I'm not sure if we should be keeping them waiting on the platform and perhaps postpone that part of the presentation to later. But I would leave that to your discretion. I just thought I should mention that. Thank you, Chair.
No, I'm mindful of that. Let's see how far do we push, because there are matters we need to attend and address with them. More so, they are newly. I don't think the NHLS matter will take much time. Because, yeah, it's a straightforward matter. Can we proceed in that order, please? Minister?
Yeah, thank you, honorable members. Thank you, Chair. Yeah, honorable members, you are aware that the NHLS was once hacked and they had very big problems and a hard time. Now, when things collapsed again a few weeks back, which they will give you the dates, many people thought, there it happens again. And of course, I also panicking, phoned them to find out what happened, only to find that it is things which are to do with electricity in Sandringham, in Johannesburg, where the NHLS headquarters are. I will then call upon Professor Koleka Mlisana, as he said, the chairperson of NHLS. Professor Mphahlele is busy with academic work. I'll call Professor Koleka Mlisana to give you the presentation. Thank you very much.
Prof, just highlight the most critical issues. Let's take the presentation as read to cater the concerns of Honorable Leroux, so that we allow members an opportunity to interact. Just highlight the critical issues and bear in mind that the presentation has been read. Over to you, Prof.
Thank you very much, Honorable Chair and Honorable Members. And we did circulate the presentation, and as requested, I'll try and be quick. So we really just wanted to take this opportunity to brief the Portfolio Committee on the recent downtime incident of our lab information system, acknowledging the incident, and then to try and provide a non-technical explanation of the root cause and the actions that we have taken. So what actually happened is that on this evening of the 16th of March, which is last week on Monday, we had a systems downtime. And obviously this had an impact on laboratories, clinicians, and patients, because what it means is that our lab information system could not be accessible by the laboratory workers as well as the clinicians for results. So we do want to take accountability for explaining this very transparently and ensuring that we strengthen, continuity of the critical diagnostic services. But I want to just state this upfront that despite the system disruption, essential laboratory services continued because we do have contingency processes in place. So just very briefly, honorable members, we have been getting continuous power outages recently, and this just outlines the frequency of these problems. And what then happens is that whenever the electricity goes out, we then move on to generators. And so you're finding that this obviously disrupts our work, and also with the interruptions of changing from electricity to generators, especially when the outage is much longer for days. I mean, like, for example, right now, we had an outage from Friday and it was only restored yesterday. And that's about 4 or 5 days, which means then we needed to rely on generators. And the minute generators run for longer, then they're gonna need to be stopped, serviced, pour in more diesel, and you restart. So these severe power instabilities have really been what has been challenging us. So what then happened, it was more an infrastructure related issue, and it was not a cybersecurity incident, as the minister has already highlighted. Otherwise, our information system remains intact, and there was no compromise to data security, and all other systems have continued to work. So basically, the prolonged repeated electricity outages, voltage fluctuations, frequent switching between municipal power and generations, and also there's ongoing cable theft in the surrounding areas. So even, the mission critical infrastructure that we are trying to put in place, it got to be compromised as a result, resulting in a database instability. So what then happened is that we ended up, having one of our key databases being corrupted, and we needed to then find, a solution and move to our disaster, recovery plan. So what we have already put in place, we do have, this has been on, it has been ongoing, for quite a long time. We've got UPS systems. As I've mentioned, we've got on-site generators, and we actually have got an automated power transfer switching, and we're able to do replications of our, data quite constantly. So the immediate response then following that crash on Monday evening, this was around 9 o'clock in the night, is that we then instituted and activated the disaster recovery environment. And as a result, our technical team was moved there. And in fact, we were able to restore the functionality by 5 o'clock the morning of the 18th of March, which meant it actually took us 30 hours to get this. And this really, the length of this was because of the complexity of recovery, coming from a database that has been corrupted to then try and stimulate and start the discovery environment. But by 5 o'clock on the Wednesday, we're all up and running. Obviously, because now everybody was trying to log in to get the information, the system was slow. I do want to highlight that. It was slow on Wednesday, but it was up and running. So as we speak, TrackCare, which is our lab information system, is fully operational, and we're operating from the disaster recovery environment. We are currently fixing the primary site, which is here at Sandringham, and we want to ensure that that reverse failover will restore that as well. So the laboratory services are stable and they're functioning normally, but I do want to alert the members, because maybe you may have heard that today we had another glitch in that our system, did hang for about 45 minutes. As a result, people were not able to access our system. We had to reboot, and after rebooting, we're able to, to function as we should be. So that did happen today, and we, the CIO is in the room, and we're trying to understand what caused that hang and how do we ensure that we strengthen, our systems. So we continue to enhance monitoring and validation controls. What about, what did this impact have on patient care? Obviously, because the system was inaccessible, it means that the registration, which is usually electronic, could not be accessed. But whenever there's a downtime, we've got protocols for our downtime, and every laboratory knows that once there's a downtime, we move to our contingency procedures, wherein there's a manual registration, there's a labeling, and we then continue to process the samples. And every critical result, it gets phoned out, because we know that the clinicians cannot access the results. So the lab continued to function, but it just means we were not able to access this electronically. But, having done that, we were able to, once track was restored, all manual processed work was then rapidly cultured into the system, and we reconciled this against the paper record. So basically, the work then that was lost, that could not be registered on the 18th of March, we then were able to log that work back. By the 20th, within 2 days, we actually had caught up with the backlog that had happened over that day. Just for the members to see what we're talking about, generally, we actually register about between 550 average 1,000 tests a day across the country, and you can see that on the Tuesday nothing was entered onto our system, but you can see the catch-up in that on the 2 days that followed, the work was then, logged onto the system. By the time we got to Friday, it was the average work that we see on any other day. And that was registration of the work. And then, as I'm saying, that the work would have been done. And so this is authorization. Once the work is done, it then gets authorized so that it can be available to the clinicians. And these are the numbers that we generally authorize, on the average per day. And you can see that, in fact, that 5,000 is because the system was, we're able to put the system up around 8 o'clock on the Tuesday, but it then went down again within 30 minutes. And that 5,000 would have been every work that otherwise auto-authorized. But you can see that on the next 2 to 3 days, we're able to catch up with authorization, so that by by Saturday, it was similar to what we often achieve. So what does this mean? It means that, yes, the downtime resulted in an intermittent service disruption of about 30 hours, but we were able to maintain operational control throughout the incident. Our recovery, to the best of our ability, was quick, it was structured, and it was clinically focused, and we're able to absorb the shock and normalize the services within 30 hours. What is it that we need to do going forward? And we have been doing this actually since, even from the cyber attack days, where we are strengthening the database protection and the recovery protocols, ensuring that every laboratory understands clearly what must be done during downtime with proper recording. And as we continue to strengthen our database protection, we are actually in the process of ensuring that we can move our servers to a protected and a fully functional data center. And I'll come to that just now. And we want to improve the failover speed, so that we don't take 30 hours to get back, onto our DR environment. And we are continuing to reinforce the replication integrity under unstable conditions and enhancing power conditioning and UPS performance. And we have obviously now engaged the management, the senior management of the City Power, because this was really triggered by the power outages. So we've been in engagement with them, and in fact, they have highlighted to us a few things. One of those is that, unfortunately, there's a huge and a prolonged construction work, on the road, on the Modderfontein Road, and it became, we were made aware that that road construction has actually altered and has sort of damaged some of the cables that are there, and this is what the city is looking at, and we are therefore exploring how do we ensure stability, and especially because as we utilize diesel, generators, we've been using a lot of diesel, so we're in discussions with the city to see how then they can compensate us for those expenses. And the other area that we're looking at is to see how we can, quickly move on to solar, especially for critical areas within our offices. And that is something that our, procurement processes are looking at. Like I was saying, some of the strategic interventions that we are engaging in, how can we then move this data center and migrate it to a hosted data center environment? And we are under discussion, at the moment with FinCom as well as with the board. We have submitted, the request for this. And this will then definitely ensure that there's enterprise-grade power redundancy, because these data centers, that's what they are created for. They have got enough power redundancy. It will also reduce our exposure to municipal power instability, and it will improve our system resilience and availability. We do want to just highlight to the members that, once we get the necessary approvals from our board, this is still going to take us 6 to 9 months, because it means we've got to move all the servers that we have that we're managing locally and move them to that data center, and then ensure that the connectivity continues. From the governance strengthening, we are updating risk assumptions to reflect the current power realities and identify ways and means of mitigating these risks. We've already highlighted that we are strengthening our business continuity and disaster recovery frameworks. stress testing, routine stress testing we are instituting so as to see how we can improve this delay and fail over in moving to the disaster recovery environment, and obviously continue to enhance executive oversight around these critical elements. So during the incident, all the heads of departments from all provincial heads of departments were informed around the track care outage from my office. The health facilities were informed via the offices of the NHLS area managers, across the country, and follow-up updates were also issued. When we were back, we were able to inform everybody that we were back, and we did obviously get media attention and were able to respond to that media inquiry, precisely. So basically, Chair and honorable members, the NHLS downtime was caused by exceptional external power instability. It was not a system failure or a system neglect, and we tried to respond decisively, and we restored the services, and the patient data was protected, and as already mentioned, the backlog was cleared within 2 days, and we continue with long-term interventions to ensure that we reduce the risk of recurrence materially. But otherwise, Chair, just to highlight that as the executive unit, we are committed into ensuring that we provide reliable lab services in support of the South Africa's public health system. I thank you.
Thank you, Prof, for the presentation, and I think you have tried your level best. Can I get hands of colleagues who want to interact with this presentation? I'm noting Honorable Clark, followed by Shavangu, by Liru, Chirampungose, and Sine, in that order, and then Mutovatse. Let's kickstart this. Honorable Clark.
Thank you, Chairperson. Regarding the outages prior to 16 March 2026, what was the impact on operations, on your operations and on patients? And while the causes aren't mentioned, were the cause due to municipality failures or NHLS failures? Can you please explain how the other systems managed to remain intact while track care was affected? You say that both the primary and secondary databases were affected. What measures have been put in place to ensure that both these databases are safe in the future, and what inspections have been done to ensure that there has been no loss of patient data? When will the primary site restoration be completed? What is the projected cost of the immediate technical interventions, including procuring solar? And what has been the outcome of engagements with the City of Johannesburg senior management? Thank you, Chairperson.
Thank you, Honorable Clark, for the pointed question. Honorable Shavangu, over to you.
Thank you, Chairperson, and thank you for this presentation.
You're not wearing the Kaiser Chief shirt, ne? On a lighter note.
I am. You know me. I'm a Dai fan. I know Minister will hate that, but I am. Thank you, Chair. And let's appreciate this information that they are giving to us, because we heard about this incident, and I think they are clarifying all the information. But I wanted to check with the NHLS, because I
Your network, ne?
Which the incidences of red lights between 7 and 9. I know it's very bad. I don't know,
It's much
but am I
better
still
now.
here?
It's much better now. Proceed.
Okay, so I was saying that before the 16th of March, the dates that they are presenting, there were some red lights. And in the presentation, they are mentioning that they do have UPS, of which I do not really understand how the whole system crashed, because these disasters will happen, these incidences, you know, your natural disaster, your load shedding, those are the risk that will happen. But if you have UPS, I do not understand, Chair, how did it lead to the system failure if they do have that. But at the same time, I wanted to check with them that given these ongoing challenges, because like I said, that it will happen, your load reduction, your natural disaster, how are they integrating this risk into their operational continuous plan to ensure that such does not happen again? Because if you're looking into the plan, the projection of them migrating to the data host center estimated at 6 to 9 months, it's quite a long period, and these incidences will be happening. What are they doing? What are the contingency plans that are there also that are being implemented across the provinces to ensure the continuity of services during the disruption? But I want to understand, how did it happen when they do have the UPS? Thank you, Chair.
Okay. Unless I lost her, but she might be done. Can I get the next speaker, Honorable Ro?
Thank you very much, Chair. And thank you very much to the presentation from NHLS and from Prof. Nisana. And yeah, I think we all obviously were very worried when that outage happened, and we had a little bit of deja vu and post-traumatic stress, certainly in the medical community. And I'm glad to hear that actually relatively quickly things were restored. And I think it seems like some of the lessons have been learned and some of the processes that have been put in place since the data breach have been beneficial. So I do get a sense that there was frantic work for a long time into the early hours of the morning, and so we do have to compliment the NHLS team on achieving that. I just had, I had similar concerns to my colleagues. I think the biggest concern is that it seems that currently the NHLS head office is in such an electricity unstable area that this is likely to happen again. And it does worry me that it's going to be 6 to 9 months before things can move. Now, when you say moving to a different data center, I understand that from what I understand, your data servers, I assume, are all in headquarters in Sandringham, if that's correct. And so my question was, when you say data centers somewhere else, is that moving all that hardware across there? Is there perhaps an option to use a cloud system? Is that what you're talking about when you're talking about data centers? So just wanting to understand that, and just to also understand what exactly. I assume that there's some, as you say, UPS or battery coverage. There are generators, but and I understand the generators cannot continue for too long. But what other backups do they have? And in terms of the solar that Prof spoke about, I think that we also, that although that might be a very positive approach, solar systems are not always that stable, and I think there needs to be a very clear if that we do go that expensive route, that there's a very careful assessment of whether this will provide the kind of power that is required and the kind of stability that is required. But my main concern is just to see what is the plan in the short term, and how are we going to prevent it if it happens again? Because it seems like, to no fault of the NHLS, the electricity around the area is very, very unstable. Thank you very much. Those are my main questions.
Thank you, Honorable Lero. Honorable Shirampungose, over to you.
Ngiyabonga Sihlalo, and greetings to the presenters, NHLS. Imibuzo yami ngifuna ukuzwa ukuthi firstly, who are the people that are contractually responsible for maintaining a track care? Is it an internal thing or a third-party vendor? And so just appraisal details pertaining to that, and the total value of the track care contract and the associated IT infrastructure. And thirdly, in relation to that, if there were any procurement processes that they were not compliant with in relation to treasury regulations, and if the Auditor General flagged any risks that are related to the system prior to what occurred. And number 4, we want to find out if there was any investment that was made in system upgrades, cybersecurity and redundancy, and why there was no failover system or backup access to take over in especially because this has occurred prior. And if there isn't such a thing, what are the future aspirations of ensuring that there is such a system in place that will provide a backup? And then lastly, Sihlalo, this is an important conversation, especially because we are having reflections and conversations around the state's readiness to implement the NHI. And the NHI will depend heavily on digital health systems. So from the perspective of the NHLS, we want to find out what guarantees that government can provide us that these particular failures or similar failures will not undermine NHI rollout, particularly on this aspect of digital health systems, because this really is a pilot program, if we may. So yes, Carlo, those are my primary questions. And oh yes, lastly, we want to find out what the financial cost of this outage was to the NHLS, if there was any. Ngiyabonga, Sihlalo.
Thank you, Honorable Shirampungose. Honorable Sine, over to you. Then it will be Honorable Mutubas and then Honorable Letlape, in that order.
Okay. Thank you, Chairperson. Good evening, honorable members, Minister, and everyone in the platform. Chair, on the corrective measures that were presented, I did not see any specific timelines. Can we get specific timelines on each and every corrective measure that was presented? And then I also want to know, Chair, what was the impact on hospitals and clinics, especially in your disadvantaged areas, your rural areas? Was there any impact on this challenge? And what were the contingency plans? Or what is going to happen now? Is there any contingency plans in place should this or care, because from the explanation, it's that it was a electrical problems that caused this. So is there any contingency plans for future? Because it looks like it will happen again. And the presenter said they are replacing generators with solars. Chair, I'm not a technical person, but I'm interested to know, what if we don't have the sun at all? I saw some people last week were complaining that there's no sun and there was no electricity in their area somewhere in Northwest. So I just want to find out why I did not keep him both. Why replacing generators and installing solar? Why not keep him both? Thanks, Chair.
Honorable Mutubatse, over to you.
No, thanks. Thanks very much, Chair. In our previous engagement with the institution, the committee was assured that a backup system exists, yet both primary and backup system fail simultaneously. And for me, that suggests either poor system design or inadequate independence of backup infrastructure, or it might mean misrepresentation of resilience capability. Power instability persisted for 10 weeks. Multiple outages were recorded before the incident. And this brings me to this question: why were there no preemptive action taken, which ties with the question that Honorable Chirompong was raised on the capability of the service provider? Was this not a foreseeable risk? And also, NHL has framed this issue as an external power supply. However, critical health infrastructure must be designed for South African realities. And power instability is not an external risk in a local context. This suggests a governance and planning failure. What is the not just infrastructure failure? What is the response of the leadership in this regard? And also, can NHLS confirm whether the GEPA system meet truly redundancy standards, geographic and infrastructural independence? And on the risk and foresight, given the 10 weeks of recurring outages, why were emergency preventative measures not implemented earlier? When was the risk power instability formally escalated to the executive level? Did NHLS revise its risk register prior to this particular incident? Who is accountable for ICT resilience, infrastructure risk management? Were any internal warnings or audit findings ignored prior to this incident? And coming back to my earlier question on systems design and infrastructure, why is it a mission-critical national system still dependent on unstable municipal power? What prevented earlier migration to a hosted or secure data center environment? Because we are hearing this now, because we are told that, obviously you are experiencing that this is what is happening. This could have been an action that was taken earlier. Why was it taken now? Those are my questions, Chairperson, in this regard. Thanks, Chairperson.
Dr. Litape, over to you.
Thank you, Chair, and evening to Professor and the team. My question is around the same issue, but for me it's different. This power redundancy of the data host center, can it not be reproduced by NHLS? Because you are a data center, basically. You hold national data. I'm just concerned about outsourcing this responsibility. Because if the data host center is in the same country as you are, why are we not funding that power redundancy that is equivalent to that you're going to rent? I'm just concerned about moving servers to a private entity instead of ensuring that we bring whatever technology they have in terms of power redundancy into where we are. Unless if we are relocating the NHLS offices from where they are. So I would want our institutions to be reliable and independent. So for me, that's my question. The other things that I would have asked, I think have been asked, even though asked differently. Hopefully, the answers will come through. But we would like to, what would it take for you to have the power redundancy that you are looking for elsewhere?
Thank you,
Thank you,
Dr.
Chair.
Litape. Thank you so much. Prof, you are on record saying that it's not a cyber attack. No, it was just purely power failure. But I should think, because you are not coming to the committee for the first time on matters related, can I ask whether you do have a cyber security strategy in place? And then if so, maybe share with us what are its pillars, also the strategic goals of the cybersecurity strategy. The other issue that I wanted also to talk to you on this matter, that I need your comment and honest response on these matters. You are this issue of the power failure going out time and again. It can't continue like that, in the sense that you are dealing there with the lives of people. You are holding that's what certain specimens that needs a temperature and control. So once you'll have this system going down, it's very sad and unacceptable. And then the other issue that I wanted also to raise is in relation to you taking long to process results. And then where I'm seated, because we are all geared to implementing NHI. So what will happen during NHI if sometimes you are taking long to process results when they are with you? I should think, don't you think it's time wherein you need to invest on solar systems and other reliable energy providing means? Because I think that I just want you to comment on that, because you are housing very important products. Hence, you need to then prioritize this and make sure that you've got reliable energy systems. Over to you, Prof, and the team.
Thank you, Honorable Chair, and thank you to the members for their questions. And what we are going to try and do is to just get, I'm going to ask the CIO to be the first one to really just look at all the questions that talk to the IT. And then, around finances, the CFO will look at those. And then the lab exec will look at the impact, on patient management. And I will then come back and just ensure that all the questions have been addressed. Thanks, Chair.
Thank you, Chair. Thank you, honorable members, for the questions. I'll start with the questions that were raised by Honorable Michelle to say what has been the impact before the 16th. Indeed, we've been suffering prolonged power outages, and this does impact our systems. We do find that, and I think it's also known that we will sometimes be down, and we would be down around maybe 2 hours to 4 hours or so to start and to try and restart these systems. But it has not been a case that the shutdown had been this prolonged like we had it now. And I guess the impact is that with the many intermittent power interruptions, your database does get corrupted, especially because it does not, you don't necessarily shut it down properly, but you do restart, so it forces itself to shut down. So maybe to explain some of the challenges that we face when that happens, you find we are going into the generator, but the data center itself, the one we run, it runs cooling, and the cooling temperatures are not in the right temperature, and we do find that corrupts the database, and this is exactly what happened here. Maybe perhaps if I may give an analogy of power failure and using a home example where we have a fridge, and let's take that fridge as the data center, and inside the fridge there's food, there's perishables that really are to be kept at certain temperatures for them to stay fresh. When the power keeps on coming up and down, this food the food might not stay as fresh as they were designed to be. So we had a corruption of a database, not necessarily a system crash. The database had corrupted because of this intermittent power failures. Then there was a question of saying, why are other systems up? Why did track suffer but not other systems? Yes, we do run other critical systems such as our ERP. They did not. And maybe if I can go back to the example of a home situation, you might find during this intermittent power supply, your fridge suffers but your TV is still on. And having said that, I'm not necessarily saying the other systems have not suffered the possible corruptions that could come with this, which, by the way, it's not only on the software side, the hardware also does suffer, and maybe that's why we saw our server hanging today. But fortunately, it has not gotten to the end, to a point where it was down. And maybe hence to prove the fact that it was not a cyber attack, it did not affect everything. However, track was down. Perhaps maybe just to mention why track is the one that is down. I think the way we look at it is that track is the 20% that makes the 80% of the other things running. The database in track is very big. We run a database that is about 18 terabytes bigger, and other systems are not that big, so the corruption took long. The question on the primary site completion, we are restoring the primary site of things I've mentioned. The database is big, it's 18 terabytes. When we were trying when we were migrating from the corrupted database into the DR site, it took us about 8.5 hours to replicate. The primary site will be ready. What we are doing is we've taken 2 snapshots, so 2 mirrors of the primary of the database that is running, but we are also then taking this opportunity to do an operating system upgrade, which is called Iris, and we are planning to go live on the primary site by the 11th of April. The cost of implications thereof in terms of what had happened. We worked as a team, but we also had to bring in the services of subject matter experts, InterSystems in particular. So TrackCare is a product of InterSystems. We brought them on board to work with us. We are yet to be built. So we brought them back, we brought them in at, we took 30 hours to restore, but we brought them in at around hour 2 when we were starting to work on these systems. So then there is a question to say, before the 16th, we saw the red light. What did we do about it? We were indeed proactive and planning. Maybe to that effect, there are many other tenders that went out in the public where we were trying to source services through, following the PFMA to make sure that we get a reputable suppliers that can help us in this lift and shift into a enterprise grade data center. But both tenders were non-responsive. We started with this process long ago, but both tenders became non-reactive. So in terms of what are we doing currently, there was a mention, and I'll allow the CFO will come in when she responds. There was a mention that we are engaging with the municipality. We also have our own data center, but the municipality as well maybe also promised that they can also loan us another data generator while we are still in this process, just to make sure that we are fine. But the DR side also, which is in Bramfontein, remains another solution. And of course, there was a question asked somewhere, what are we doing? Why are we not looking at cloud and stuff like that? That is also part of our pipeline in terms of what are we doing to make sure that we have a proper redundancy. And maybe coming to questions that were asked by Honorable Leroux. The head office is indeed unstable. 6 to 9 months, yes, it is long. However, that's the indications that we got in this non-responsive tenders that we are now maybe going to even try and go to procure by other means, because we've been having non-responsive tenders. The project timelines that we've been given are indeed showing that we can take about 6 to 9 months. Perhaps maybe just to explain what it entails, we will have to shut down here, lift and get that other side, connect and wreck again. Why does it take that long? We need to then make changes in terms of our network switching to make sure that when we get the other side, we are able to work. But however, the timelines we are given by the service providers that had responded in the tenders that were non-responsive. Maybe let me get into the question of cloud. I guess Honorable members would know that maybe the way technology is moving, people are thinking cloud first. So it is also part of our pipeline when we're looking at the track system. Track themselves have come to us to say their next upgrade after the version that we have is necessarily a cloud one, and we are looking at the options of saying how when we are going to be migrating there, so we're going maybe into a more private cloud because of the sensitivity of the data that we are holding. But our track system is due for upgrade. Intersystem or any other track systems or any other lab information system that are out there are necessarily running on the cloud, and we are exploring options of when we do go to the cloud, we then have our own private hosted cloud. And we've started with our own private hosted cloud with one of our applications called the CDW. As mentioned, the plan in the short term, yes, there's procurement plans to get solar, but we are looking at having 2 generators, and we still have our Bramfontein as the DR site as a backup. Perhaps maybe just to get into why were we not able to switch over immediately, because we get intermittent power supply, and with backups we schedule them to run at night when it's not busy, and you find that when there was an interruption, then that backup did not run successfully. Hence, on the day of the downtime, we could not just switch over because the backup site itself was not having the latest snapshot that we could just switch over. As a result, we had to migrate this very corrupted full database into to the other side. Moving on to questions that were asked by Honorable Shiva to say who maintains track. We have our own in-house team made up of medical technology specialists and IT specialists. And we also, like with any other ERP or big system, we also buy maintenance and support that supports our licenses. Hence, we could call on the inter-system people to come and help us when but we are mainly in-house supported, but we do pay maintenance and support, and we have some hours where we are assisted. Maybe just to add on that we do, because necessarily our LIS is the core of the health services. We do integrate with other systems, and when that happens, because it's a development and we are developing into a product of intersystem, we do call on them to do the development. There was a question on whether AG had flagged on the infrastructure. I think honorable members would know, and with the recent report that we got on from AG, they did flag that indeed as NHLS we are running aged or aging infrastructure, and certain things are therefore not necessarily possible to be done. Things such as automating your patching on the system just to keep the whole infrastructure hygiene happening are a challenge because of the aging and the aged infrastructure. And to that effect, we have we have a plan in place, and we also have to follow the governance and the procurement process to get those in place. The systems upgrades that were done after cyber, we came before yourselves and we reported that we've made strides in terms of what has been done. But maybe just to mention that in terms of the upgrades that we did, we started maybe the biggest one that we worked on was our core switches for the networking, and the project called LAN Phase 3, and it's now coming up to its conclusion. And we started there. We also, because in terms of the AG findings and what we did not have, we also did not have a cybersecurity operations center. We invested in that. We appointed Data Proof, and we have a cybersecurity operations center that is looking at our environment 24 hours. We also invested in a cybersecurity awareness tool where we are on a monthly basis running cybersecurity awareness campaigns with our users. We've also invested, because you would we had sort of inferior Microsoft licensing. We then invested in Microsoft licensing that are E5, that gives us the security, and that also gives us the capability to be able to run certain things centrally, such as your Intune. The other question, maybe if I may move to what Honorable Sinna asked, to say what corrective measures are we putting in place and what are the timelines. In terms of strengthening the database recovery protocols, that is happening. The backups are happening every night, but maybe as mentioned before, when we're going into the prod, we are looking at upgrading the operating system that works on LIS, the IRIS, and that timeline there to be back at the production line is 11 April. We spoke about, we are reinforcing we are enhancing power conditioning through UPS performance. I've mentioned that we are looking at getting a backup generator, which the city of Johannesburg has actually promised to say they can always loan us, and it's a question of us asking them on time. The CFO will talk deeper on that. And she will also touch on to the issue of the solar and the solar replacement. Okay, and maybe just to mention that while the CFO will touch on the solar and what are we looking at in terms of costing, our aim is to have both alternate power generation, and we are not necessarily replacing generators with solar. Our aim is to have both running. Then there was a question on the questions asked by the Honorable Chair to say, do we have a cybersecurity strategy? Yes, we have a cybersecurity strategy, and we recently had an IT strategy approved, and the cybersecurity strategy is underpinning what is in the IT strategy. Perhaps, Chair, the question was, what are its pillars? It has got 6 pillars, and the one pillar being about governance and how we govern our environment. We're also looking at the identity pillar, so that we know who is in our environment at all times. We're looking at the protection pillar, looking at the security measures we're putting in place to protect our environment. We are also looking at the pillar called the detect, and maybe just to mention, we are following the NIST framework. The detect pillar, so that we can always detect when there's intruders in our environment. We are also looking at a pillar called response, and this talks to our business continuity, our recovery, and our incident response plan. And we have a pillar called the recovery, that touches on what happens when we are to recover and what are we recovering. And I guess the response pillar talks to what our account jewels and what do we do when Rome is on fire. Just to mention again, track is our very core system. Is the 20 that makes the 80 works, and we do raise it as a priority environment. The backup and the okay, the backing of the towards the data center. Perhaps maybe just to mention that part of what we're doing, we also are having we are going on procurement process on that one, to say we also are looking at a partner that will help us with the managed backup services. We're looking at having in backing up, there's a strategy called the 3-2-1. That means you must always have a 3 copy of whatever you are backing up, one on site, the one you are running, one on site and one off site. We are also looking at the service provider that comes on back will help us with the managed service to do that, but most importantly, to have a very off-site backup, such that when we are down and we can't rely on our 2 backups that we are running, maybe we don't need to spend the 8 hours trying to copy it within, and we can take from that mirror. There was a question to say, why are we not looking at building our own data center? And we keep on saying we are moving. We would like to, we looked at it and we said running data centers and maybe running, let me call it, rooms that are cool with consistent power supply is not our competencies. There's our subject matter experts out there. There's data. There are people who own that competency, and they can rent us a space. So what we're looking at is really having our own and secured. When you go into these data centers, they will cage it to say this is an NHLS rented site, and we will put all our 27 racks there. The one data center that we had identified is the one that has been long serving in the country, Terraco in Esando. That's what we were looking at. Honorable Mutubadze asked whether the current backup does really subscribe to the standards of DR and disaster recovery, and the answer would be no. The standards are that if we're saying we have a DR, it must not necessarily be within a 50-kilometer radius. Our one is currently Braamfontein to Sandringham. It's definitely not within 50 kilometers radius. However, we are also not necessarily investing in building it to be a very high-tech one, because as technology advances, you can have it in shorter distance areas, provided you've done certain things and you've put certain technologies. We've opted to have a hosted data center where we take our own servers and we put in somebody else's who is well run and well graded data center that guarantees us 99% uptime. Who is responsible for IT and these backups? I would say as the CIO, I am responsible. What has prevented us doing these things earlier, the migration earlier? Nothing has prevented us to doing it earlier. But as mentioned before, we have been on two procurement processes, and these two procurement processes, honorable members, we started the process in May, and maybe just to mention that one joined the organization in April. We started the processes in May in terms of backups and moving the data center in particular. Nothing was preventing us, and we are hoping that we will be we will meet the 6 to 9 months following, as we mentioned in our slides, following governance approval, because we are now looking at an option of procuring by other means, as the normal procurement process was not responsive. Maybe let me pause there. I'm not sure what have I missed. Thank you. Over to you.
Okay. Thank you, Chair. I think, Chair, the CIO has covered most of the items that I would speak to. But I just wanted to indicate around
If she has covered most of the item, don't repeat yourself. We still have another presentation, eh? So speak to the issues that she didn't cover.
I just wanted to comment. All right. Thank you, Honorable Chair. So I just wanted to comment around the engagements with the municipality. So the current engagement that we managed to secure as management was mainly with a more technical team that took us through what the challenges are. And we then they basically have committed to really providing more support to make sure that there isn't much interruptions that are coming through the various support. But also in respect of the procurement of solar, I just wanted to give the assurance to the honorable members that it's an augmentation. It's not only the only means that we're going to be using in terms of the alternative energy. And we have noted the comment in respect of the fact that we need to then identify other reliable sources in respect of that. Thank you, Honorable Chair. I will stop there.
Thank you, Chair. Maybe just to round off then, because I think most of the questions have actually been addressed. There was a question around our readiness, especially because we're hosting such critical data and even patient samples around NHI. Yes, we are very much aware of that, Chair, and that is why we are committing and want to ensure that our environment actually is built to have the best security and sustainability of such important data. In fact, we do have, and we've already looked at the whole issue of data and how we're managing it and how this data can then assist even in how we manage the health system within the country. So, Chair, we are very much aware of this, and all the plans that are getting put in place are to ensure that there is integrity of that data and that is maintained. I think let me end there, Chair. Unless there's any other question that we may have missed, we can then get direction from the Honorable Chair and Honorable members. Thank you.
I think we have exhausted this agenda item. If there are questions that members would want to make follow-up, they will do so in writing. So be ready for that. I'm trying to...
Thank you, Chair.
Thank you so much. Then we are going to ask the HPCSA to come to the fore. Minister, is anything that you want to say, or they can just proceed with their presentation?
Yeah, Chair, simply to say, as you have said, there's been a new committee altogether, which has been inaugurated, but also an interim register after the former registrar's contract, came to an end because of retirement issues. So we are having a totally new people here who, by the way, have actually dealt with the issues, and they are going to take over the questions that we have asked from the previous committee. And so I will allow, I don't know whether it's going to be the interim registrar, Dr. Kemicheti, or the chair and the president of the council, Professor Klita, who is going to present. I'm leaving it over to them.
No, thanks a lot, Honorable Minister, and I want to thank Honorable Chair and the members for the opportunity of the HPCSA Council to present ourselves here. Yes.
Are you soft-spoken, Prof, or is that issue of the mic that I raised earlier?
I suspect it's both of them, Chair, but let me not waste time.
Sure.
Honorable Chair, let me not waste time. I will hand over to the interim registrar. She will take us through the presentation.
Thank you very much, Honourable Chair and honourable members. Chair, we tried to cover as many of the questions that the committee did raise in the November meeting. But some of the slides, with your permission, Chair, because of the lateness of the hour, I can just very quickly go through it. As you can see that the details have been given. So basically what we're going to be dealing with, Chair, is the complaints management system. Then we're going to look at the issue of restoration of names to the register. There's an issue that's been raised about the health market inquiry, and then also the national health insurance, and an issue has been raised around our engagement with the public. Very quickly around the complaints handling, there's been questions raised about the finalization of complaints against registered practitioners. There were issues raised about the dissatisfaction by complainants with regard to the decisions made. There's been questions asked around the backlog and turnaround time, specifically on the restoration processes, the penalties that have been imposed, and then on the health market inquiry, the issue of the implementation of the recommendations, then also on the engagement that we have with an emphasis on the rural areas in order to raise public awareness, and our role with regard to the NHI. Chair, with regard to the issue of the complaints process, the HPCSA in about 2024 strengthens its educational campaign to inform and guide members of both the public as well as practitioners on the complaints management process. And as a result, and I'll show you some stats there has been an increase in the number of complaints received against registered practitioners. In order to improve the efficiency of the system, we have got an online complaints management system, which has been implemented since June 2022. So the system allows for the lodging of complaints on our website, and we can track these complaints by members of the public and practitioners. So just to give you an idea, Chair, we've pulled out the data on the complaints registered against all the different boards for the different financial years. And I'm not going to go through the numbers, Chair, but you can see that most of the complaints is at the medical and dental board. And then we also gave you the percentage increase, and you'll see that in 2024, after the awareness campaign, that there was a 17% increase, and in 2024-2025 there was a 24% increase. So we've just provided these stats as requested by the HPCSA. Sorry, Chair, For some reason, it's my slide is not moving. Thanks. We've outlined in this table the complaints management process. I'm not going to go through the details of this, Chair, because it gives the details from the when the complaint gets received, and
I seem to have
complaints
lost them. Okay.
sorry, Chair, can you hear me now?
Yes.
Okay. I'll also try and get closer to the mic. So when the complaints come in, there's a whole process where the complaints do get triaged, and then we will see whether it belongs to the HPCSA or not. We then, some of the complaints will go to mediation. And if it doesn't go to mediation, then we will investigate the complaints, and then it goes to a preliminary committee of inquiry. Thereafter, it'll go to prelims if it's not a minor complaint where penalties get charged, and if that gets appealed, it will go to a prelims appeals committee according to the regulations. If it's not resolved at that level, then it will go on to the professional conduct inquiry. And then we'll also look at whether it warrants precautionary. And then we've got an appeals process following on the professional conduct inquiry. Chair, I think that the details around each one of those is for the portfolio committee's information. Unless you want me to go into the details during question time. But this slide, the next slide shows you requested an idea of the turnaround times. So what we did is we in 2021 we had a certain turnaround time, and currently that has been revised and the turnaround times have been reduced. So we've given you the turnaround times for each step. Like, for example, 70 days for mediation, it's 5 months for the investigation, 3 months for the prelim inquiry, and then 10 months for a professional conduct inquiry, because more often than not, that's when we would have legal representation, so that process takes a bit longer. And then with precautionary suspension, because of the it's a decision that's quite complicated, so that takes about 3 months. Chair, just to say that as part of the of our turnaround strategy, you'll see that we'll mention it later on. To look in what way we would be able to reduce it. That's part of our strategic plan for the next financial year, but we started with the process already. The next slide, Chair, again, it's for information. It's to show the number of complaints that we've received over the last 5 financial year. And then the number that so we only handle complaints against registered practitioners, and this so that's why the number has decreased from the number of complaints that have been received. We have given you details then as to how many get finalized when we look at the perusal and analysis stage. Here, what we mean is that we either refer the complaint elsewhere, or we just complete it to, well, it may have to go to another unit within the HPCSA. Then we've given you the numbers for mediation and the percentage of the number of cases that get finalized at mediation. We've done the same for the investigation phase. This next slide, the committee had wanted to know the backlog. So what we did here, Chair, is that we, and honourable members, honourable Chair, We took the turnaround times that have got, and we looked then at the number of matters that exceeded that turnaround time, because that represents the backlog. And you can see that the majority is within the professional conduct inquiry. We're very conscious of the fact, Chair, that it's a large number, and we are working on ensuring that that backlog gets cleared out. So we've given you the expected finalization dates. So for mediation, the total backlog will be finalized by April 2026. For the investigation, the 44 matters are going to be finalized in April, and then we'll also try and ensure that the 8 outstanding matters will also get finalized. We've done the same thing for the prelim inquiry. So what we're doing there, Chair, and we got that as part of the action plan, is we've asked the prelim inquiry committees to sit more frequently, and we're also increasing the number of days for the meetings in order to reduce this backlog, finalize the matters by June 2026. And then we're also doing the same for, in fact, the prelim appeals would have been finalized now whilst we're sitting. The issue is around the professional conduct inquiry, but there are some matters that have been partly heard, which will be finalized in May 2026, and all other matters we want to set down by September 2026, Chair. We've identified the gaps within the system. One of the issues is we want to change the regulation, which provides that the prescribed turnaround time for practitioners to respond to allegations is 40 days, and it's 40 working days. So that makes it about 2.5 months. We want to reduce that time because with the technology we've got now, we think that it can be reduced, and that will make a big difference. That is the only turnaround time in regulations. The other turnaround times is what we will be doing internally within the HPCSA. There is a problem that we've got with the limited pool of available experts and the rates that we're paying for those experts. But we recognize that those gaps is what we can manage, and we've started the discussions as to how best we can improve the pool of experts, and we are reviewing the rates as well. The private sector pays very high rates for these experts, and it does become difficult for us to compete with them. But we recognize again that it's something that we can look at possible solutions. I won't go through the other details. There are issues around provision of hospital records. There are issues around availability of the parties, and litigation that does delay the whole process. And there's also the whole process around requested information that we request from the parties. But again, Chair, we've identified these gaps, and in our internal discussions, we've said that we can look at, we can manage these gaps. We've put it down for information to the portfolio committee. We've put down an action plan that we've put time frames to, and what we will be doing. Chair, it's the time frames is something that we also recognize. We can do it within that time frame, but we'd much prefer doing it sooner. The regulatory environment, I've spoken about the regulations that will need to be changed. We're looking at business process re-engineering. I've sat with the team. We said that we need to look at the whole case management system and look at the tariffs and the whole process in order to look at how best we can redesign it to make both to deal with the backlogs, the current complaints, and to get the whole process managed much more efficiently, because we recognize again that it's one of the key areas of work for the Health Professions Council, and we've also put as part of our time plan data management as part of that. It's a simple issue, but we just kept it in around the translation of complaints. And then we've already discussed the additional capacity that we'll be looking at in order to reduce all of those backlogs, both with experts, because we've discussed now getting a panel of experts together. The immediate action plan, I think I've discussed this already. This just highlights it. We've immediately started increasing the frequency of the prelim committees, appointment of additional resources, and the internal system around each one of these areas. Chair, then specifically you asked us to discuss the issue around the complaints received from the different complainants. Because of the POPI Act, we haven't put the complainant's name nor the practitioner's name here. We've just put it as complainant 1. So this matter, Chair, the prelim committee has met twice already in order to consider the complaint. The explanation from the provider was accepted, and the prelim committee has closed them. So from the HPCSA's point of view, the internal processes have been exhausted, and the next legal recourse is to approach the High Court, and that has been conveyed to the complainant. I'm not going to go through the details, but we've just given you.
Please note my point of order.
Okay, noted.
I see in the presentation of HPCSA on practitioner 1 on the current status. In their presentation, but the matter was referred to inquiry, and the matter is set down in June 2026 as agreed between both parties. They are misleading us because the person in question here, Dr. Mufokeng, did not agree. She told them that she's not available on the date, and they decided to proceed ahead. Why are they telling the portfolio committee things that are not true?
Okay.
What is it that they agreed between both parties? Which both parties are these? Thank you so much, Lal.
Yeah, can you hold it on there? Ne? Let me allow her to just finalize. In fact, these things are read. Can she wrap up so that you'll be the first one already? You post your first question. The acting registrar must know. And if there are any other misleading things, I don't think I have to emphasize the consequence thereof. So, yeah, can you move towards finalizing a registrar so that we can deal with the issues at hand?
Thank you very much, Chair. Okay, so I was just completing the complainant 1, which is we've given you the turnaround time there as to from when the matter was lodged to when the matter was finalized. Practitioner 1, again, we didn't put in the names, and the information that I have currently is as it's written there, that the matter was set down and it was agreed between both parties. But Chair, can I just add that I have requested a legal opinion on the issues raised by the portfolio committee around the immunity issue, and we are awaiting that legal opinion.
Before that, I'm reading something, a very interesting thing on the chat, registrar, as you are presenting. Somebody is saying, Poppy Act. This complainant issued a media release celebrating the charges of Dr. Taleng. In essence, he also put the link there, the writer. and then they outed themselves, and then they must be named.
Chair, I'm not totally certain because we can't see the chat. We had taken the Poppy Act into account in order to, and that's why we haven't put any names. But it was an issue it was an issue raised by the Health Portfolio Committee, I think.
Yeah, on a point of order,
When,
who's this person who's contributing?
There's a point of order here. I should think also you joining them, ne? Before I allow the point of order, you might have been misled, Registrar. I raised this earlier before we started. The longer it took them to respond to our question, that's why you find things like this. Dr. Liro?
Chair, on point of order, I am just confused that I don't know who the person is who is sending these messages on the chat in Zoom. I don't think they're a member of the committee, and so they should not be contributing to this meeting in that way. They seem to be trying to influence the proceedings of the committee by posting things, and I find that quite disturbing. So I just want to get your ruling on who this person is and why there are things being posted in the chat. Thank you.
Okay, but we're also, okay, I hear you on the other side, but also I should think I'll have to also consult on this matter because, talking they can talk, but on the chat, that's the other issue. I'll have to get clarity with how we hold our online meetings. I think that's what you're proposing, unless somebody has gone through the rules, but this is the matter I'll look at. But you are thinking is that it's influencing the outcome, whatever is there, maybe can I plead with, because these meetings are open to the public. Maybe our secretariat should have disabled the chat thing. But then can I plead with all the attendees for the sake of progress? If there are things that you feel they are devoid from the truth, just hold them for yourself. Then you can send them to us in the form of questions. I'm doing to rule that for the sake of progress, so that if there are issues that you want to ask, if you feel that there are certain things that are devoid from the truth, you can still write to us as the committee, and then we can follow them up as a committee for you, and then we'll respond to you. Yeah, I think that order assists. Let's move. Thank you.
Thank you very much, Chair.
There's a hand of Honorable Mtubatse. Before I do that, Honorable Mtubatse?
No, Chair, let us just clarify this matter. I think it's simple. You don't have to go and consult. I think the decorum of the House is that members of the public, there's a space where they're allowed to sit, but they don't participate on matters that are within the House. And the same thing will be applicable if we are in this platform. No one is allowed to interject and participate in what the committee, because this is within the decorum of the House as stipulated by the law. So that must be clarified. And I think maybe in future what we should do is that at the opening of the meeting, you must caution members of the public who are participating, because we can't close them out from participating, because that is what this parliament is there for. In my view, that's what. Thanks.
Thank you. Indeed, this meeting is deemed to be in the precinct of Parliament, and the rules that relate to the physical meetings apply and are also applicable to virtual meetings. That I would say. Then for non-members, the committee can also be able, the secretary can also be able to disable the chat icon. And then you'll have two separate participants, and also, that's the thing that will deal with that. I think that order is sustained, and I think my earlier rulings to those who feel there are things that are not being, that are in the gallery, you can write to us those things and then we'll follow them up. So let's allow whoever is typing to stop from doing that so that we can proceed with this meeting. Move towards conclusion, Registrar.
Thank you very much, Chair. I think I also was mentioning that when we sort of listened again to the portfolio committee recordings, or at least I went back to go and listen to it. I've asked now for an urgent legal opinion on the issue of immunity that had been raised by the portfolio committee. We're currently awaiting that legal opinion, Chair, and I think importantly, as soon as we get that legal opinion, then we'll be able to respond to the portfolio committee as to what the outcome of that is. Thanks, Chair. Sorry, the thing is not moving again. Chair, these also relate to the other issues raised by the portfolio committee. I won't go through the details of it. There was an appeal for complainant 2, and we can provide the name to the secretary of the portfolio committee, but we have outlined what the complaint was. And as the matter is tabled again for the 26th and 27th of March for consideration, giving you the time frames there. With complainant 3, the complainant did raise dissatisfaction, but in a similar way, our internal HPCSA processes have been exhausted, and the complainant has been told about the next legal recourse. This just gives you the number of inquiries over the last 5 years and what has been the penalties that have been imposed for those that have been finalized. Then, Chair, the question around the restoration of the practitioners back to the register, it's governed by Section 19A of the Act. I'm not going to go through the details of that, but the restorations, it has to go through the prescribed form, and there is restoration fees that we that when you haven't been registered for a period of 6 months, what the restoration fees are, and then it gets steeper within 12 months and steeper thereafter. We've taken into consideration the comments made by the portfolio committee, and again we are reviewing now these restoration fees. It's part of our strategic plan, and we will get back to the portfolio committee thereafter around these restoration fees. The balance is going to be around ensuring that it doesn't become a habit of providers to not register because the restoration fees are so low that it doesn't become a disincentive. So we have to make sure that we create that balance so that we keep providers registered at all times. That's what we want to encourage. Those who are, we keep providers registered at all times, because it makes it a lot easier for the provider themselves. Chair, I'm going to go very quickly over this. The health market inquiry flagged concerns with the HPCSA's ethical rules. Can I just state that with most of the flagged concerns, we have changed the rules, and it's just one issue where the rule had been changed, but there were concerns raised by stakeholders who were concerned about the consultation process. So that rule then had been sent back, we now going through the process of consultation with regard to that rule. It concerns the employment of doctors. Sorry, Chair. It concerns the employment of doctors, and we are going through the whole consultation process. These just gives you an idea of all the different booklets that we've got on the ethical rules. Most of them have been reviewed and updated, but there's a few that haven't been updated, and we're busy in the process of updating this. And then with regard to the national health insurance, we governed by the Act, which clearly states that, which is the objects and functions of the Council, that we determine strategic policy in accordance with national health policy as determined by the Minister, and we make decisions in terms thereof.
Registrar, that one
Yes.
is in the Act. Members are aware. Move to the next slide.
Thank you. So we will follow the prescripts of the Act in being able to determine the policies with regard to the Minister's National Health Insurance Act. And then, Chair, just lastly, the issue around public awareness and engagement. We've given you details of all the community outreach programs, but we're very cognizant of the fact that you did emphasize the rural areas especially, and that's been taken on board in our stakeholder engagement strategy. We recognize that communication is so important that even if we say we've done so many, that it can be strengthened on a continuous basis, and that's our intention, Chair. We've given you annexures to show you, all the radio stations we've been on, what type of engagement, and what our program's going to be. So I thank you, Chair. That's the end of our presentation.
Thank you, Registrar, for the presentation. If you can remove the video from the screen. Thank you so much. Can I allow Honorable Chirwa? I told you you're going to be the first one, followed by Honorable Clark. These are the only two hands I'm dealing with. In the meantime, these are the only two hands. Honorable Shabangu has indicated she's affected by storm. Then there's Honorable Mtobatse, Honorable Letlape. Yeah, in that order. You can start, Honorable Chirampungose.
Ngiyabonga Sihlalo, greetings to yourself again. I'm happy that the Minister is still in the meeting. Greetings to the Minister again, and to the colleagues and to the HPCSA. We'd like to thank them for their presentation. Sihlalo, I also want to greet Dr. Tlaleng Mofokeng. We did invite her to come and observe in this meeting together with her advocates who are following the proceedings zanamhlanje. Okokuqala, Sihlalo, I'm having a very big problem with HPCSA coming to this portfolio committee today to tell us that they have now, as in, I'm assuming that Mabati, they've now just sent a queue for a legal opinion on the immunity of Dr. Mofokeng regarding this matter. It really is undermining the portfolio committee. We had this meeting in November 2025, and they were meant to send back responses within 7 days. That was the agreement in that portfolio committee meeting. Okokuqala, abazange bawathumela ama-responses of the questions that we asked. And one of those questions was pertaining to the fact that where did they get the jurisdiction to be able to continue with legal proceedings and even find a UN special rapporteur guilty and even find them and having lifetime ramifications on her career as a practitioner in South Africa, because she has special immunities that are granted to her through the United Nations. And second to that, they had not consulted with the United Nations because they were not able to say that to us in that portfolio committee meeting. They had not consulted with DECO, and clearly they had not consulted with the minister as well pertaining to this issue. If they had, they must appraise us on how those interactions went by with the minister, if they did. Chairperson, it really is a concern, posture HPCSA in its handling of the matter that involves Dr. Tlaleng Mofokeng. We've already established quite numerous times that we are having a problem, even with the CMS yesterday, with how these entities handle the issue of Black practitioners. And this cannot be stomached and tolerated any further. We raised numerous examples of Dr. Passon, whom they took a long time to be able to take action against him. And Nakona, they were taking their precious time and using kid gloves to handle the matter of Dr. Passon. But Dr. Tlaleng Mofokeng, they acted upon it very quickly. The HMI is very correct to say that they have ethical issues on consistency, which is something that we are raising even namhlanje. Uguti, how do they decide which case to prioritize and which one to let go for 20 years? How do they make that decision to say, Dr. Mofokeng is very important because she is fighting with Netanyahu of Israel, who's murdering children and women, who's a genocidal maniac, as opposed to Dr. Passon, who has his own dealings and his own catastrophic dealings in South Africa. We don't afford an HPCSA that functions like we're in an apartheid South Africa. That's number one. So they really have to come back and give us a namhlanje. They can't say that they just reached out for a legal opinion. You've been knowing that this matter is a priority in this portfolio committee. In fact, we had initially written to the chairperson of the portfolio committee as the EFF to call you in to appear to us concerning this matter. You cannot cite the Popia Act. You were aware that this meeting was about Dr. Tlaleng Mofokeng when you came in. So I don't know where do you now start citing these things to cover yourselves. In the previous meeting, you also made a misleading assertion in this portfolio committee, and you were called out for it. Today you come back and you repeat it. You repeat misleading the portfolio committee and say to us that Nina and the affected parties agreed on a date to continue with this matter when you know very well it isn't the case. She already stated to the HPCSA that on the 9th and the 10th of June, she will be in Geneva doing her duties as the special rapporteur to health in the United Nations. You already knew this, and you responded refusing a postponement, meaning that you are willing to go ahead with these proceedings without the person who is being complained against by the Israel lobby group in South Africa. You are willing to go ahead and still penalize her when she won't even be there to be present to defend herself. How do you operate in this manner? And you know it is wrong because in your knowing that it is incorrect to behave in that manner as an entity, as a public entity of the NDOH, you have to lie about it in your presentation. Because had you written in that presentation of yours that yes, we said we want to do a proceeding on the 9th and 10th of June, but she's not available, but we're going ahead whether she likes it or not. You know that we were going to have a problem with that as a portfolio committee. So you decided to once again mislead us. You must answer to that too. Why do you consistently mislead us on the issue pertaining to Dr. Tlaleng Mofokeng? Why is it a must that you can't be truthful when we speak about Dr. Tlaleng Mofokeng? You sent us two specific replies on the two cases that were also raised in that portfolio committee meeting. You sent us detailed replies. But on Dr. Tlaleng Mofokeng, now you are giving us Poppy Acts and you couldn't send us a in detail response as part of the cases that we raised on that particular day. You must tell us namhlanje ukuthi inanicele illegal opinion enicele manje when you've been knowing about this for months on end and that you had to respond in 7 days, which you failed to do. You must tell us now today, where do you get the right? And then second to that, you must tell us what have you found this person guilty of? Because even if she had to prepare for the 9th of June, you still have not given her the reasons of your findings. Honestly, Chairperson, we cannot allow the HPCSA to do this to a black woman doctor who has served the country, even in the CGE, and who continues to serve the world at large for fighting with Netanyahu, who's a genocidal maniac. A South African public health entity cannot be utilized as an ideological tool to come against people who have different political ideologies. Show us the patient whose life was put at risk by Dr. Tlaleng Mofokeng. It's a known matter. No need to cite the POPIA Act. She is consenting. She is in this meeting. Don't hide yourselves behind these legal processes. We want to know because you've been knowing about it, and we've been saying that we want to find out ukuthi kwenzakalani. And then you must also appraise us what you utilized to make your findings on this particular case. Outside of the reasons, you must appraise us on your scope of attending to this thing. And I know you've also attempted to shield yourself from this because in your presentation, you cite that in some cases you hire private experts to do these investigations. And I am sure that you are saying this in order to mask yourself from accountability. It cannot happen. You are not able to account in the last meeting where you came specially for this case, by the way. You came specially for this case, couldn't give us answers, were given 7 days extended to answer the questions. You still didn't answer them. You are coming here again for the third time, and you still cannot answer us. You're telling us that now, registrar, right now, you're saying in the presentation you've just reached out for a legal opinion. That cannot be allowed. That absolutely cannot be allowed. It means you guys know that what you're doing is wrong, and you must retract this whole process that you have done. It's fraudulent. It's fraudulent. Even the person that you're found guilty still doesn't have the reasons, still doesn't have the scope, still is not capacitated to come back on the 9th and the 10th to respond and defend herself. And you've been lying about this process. You've lied in the portfolio committee and are still doing that even today. This cannot be tolerated. I'll come back for follow-ups.
Thank you, Honorable Shirampungose. I hope the President and the Deputy President is listening. And I think out of this, there should be some remedial steps that the leadership will take. Because honestly, we cannot be taken for granted. And then we'll have to hear of the consequences. I'm going to mention the name of the officials who were in that meeting, who are still within your employ, President, as we progress. Honorable Clark.
Thank you, Chairperson. I've just got one issue to raise. I would like to know how much additional resources are needed to clear the backlog and what would be the cost thereof, and how long to clear the backlog should you get these resources. Thank you.
Thank you so much, Honorable Clark. Honorable Mutowate, over to you.
No, thanks, Chairperson. I don't know where to start, but let me start here. During the previous appearance, assurances were given regarding improvements, which specific commitments have been fully implemented, partially implemented, or not implemented at all. I want to know why are we having that situation. And just as this disclaimer, I have many questions because the questions that were written, that were submitted, now we find that it is difficult, and I think maybe members must write them down so that we can have a comprehensive response to these questions. Now, secondly, would the institution agree that without strict timelines, transparent reporting, and consequence management, including consequence management to this leadership itself, because I must say I don't take kind that the committee must be misled. And from what has happened now with what Honorable Chirwa has actually said, I'm sitting here with the conviction that we have been misled, and we have been misled deliberately. And I don't take kind of that. And I don't think Parliament should take kind of that, because we are that institution. The issue that I want to, questions that I want to raise, first, starting with the complaints and the backlogs and the turnaround times. You indicated an increase in complaints due to awareness campaigns. What is the current backlog figure, and how does it compare to the November 2025? What is the average turnaround time from complaint lodgement to finalization? Because that's the issue that we raised earlier on, because we don't have time for cases that will last for a long time, and how many cases exceeded their time frame. What consequence management exists for internal delays within the institution processes? Can you provide monthly trends analysis of complaints received versus finalized since June 2022, post-system implementation? What independent oversight mechanisms ensure fairness and consistency in disciplinary outcomes? Is the system coping, or has awareness simply overwhelmed the structurally weak complaints in the system? The online system was introduced in 2022, as per your report. What measurable efficiency gains has it delivered? What percentage of complaints are successfully tracked and resolved digitally without manual intervention? How accessible is the system in rural and underserved areas where digital access is limited? Because we serve the country, and in other areas we having these challenges. Has the system been externally audited for reliability, cybersecurity, and user accessibility? Is this reform transformational or cosmetic? Now, when coming to the quality, credibility, and disciplinary outcomes, there is a public dissatisfaction with disciplinary decisions. What steps have been taken to standardize sanctions and ensure proportionality? How often are decisions successfully appealed or overturned? And what does it say about the integrity of the process? What safeguards exist to prevent leniency in case involving serious malpractice? The committee previously raised concerns about the exorbitant restoration penalties. What reforms have been implemented? How do restoration fees align with transformation goals and workforce shortages, especially in the rural areas? Is there a review mechanism for practitioners unable to pay restoration fees? Critically for us, are fees regulatory tools for exclusionary barriers? Now, let's come back to the health market inquiry. Fortunately, we were discussing it yesterday. While 15 of 19 rule booklets have been reviewed, what is the timeline for finalizing the remaining rules? Why was the ethical rules 18 reversed after stakeholder pressure? Does this indicate regulatory capture? How is the institution balancing private sector interests versus the interest of the regulation? Is HPCSA leading reform or reacting to pressure? I think that's the key question, because what we see now with the current case that is being presented here by Honorable Chirwa, my suspicion is that you are not leading reform, but you are reacting to pressure, and not only local pressure, but international pressure, and with coming from people who are practicing genocide and with big money. Now, that suspicion, it's up to you to help us to put you in the green light. Now, how does the institution ensure independence from professional lobbying groups and private healthcare interests? What measures are in place to prevent conflicts of interest within the statutory committees? Has there been any external governance review since the last committee engagement? I'm only left with 3, Chair. Given your statutory mandate, what concrete preparations has the institution made to support NHI implementation? How is HPCSA addressing human resource constraints, particularly in underserved areas? What role will the institution play in ensuring quality assurance under NHI contracting mechanisms? You reference expanded outreach. What quantifiable metrics demonstrate impact in rural communities? How many complaints originate from rural versus urban areas, and what explains that disparity? What partnership exists in local governments or civil society to improve awareness? Because you told us that you have got an outreach program that you are running with. Now, civil society plays a critical role in that regard. And how is their involvement? What is the partnership that you have with them? Will the institution commit to publishing quarterly public dashboards on complaints, disciplinary actions, and backlogs? Why are detailed performance metrics not proactively disclosed to Parliament and the public? Lastly, Chairperson, on capacity and resource constraints, what are the staffing levels, complaints, and legal divisions versus workload demands? Has HPCSA requested additional binary support? And if so, how has it been utilized? Thank you, Chairperson.
Thank you so much, Honorable Mutubate. Honorable Litlape, over to you.
Thank you, Chair. I have provided proof of life. My first question relates to the restoration fees. I mean, they would make loan sharks deal with envy in terms of the size of the penalties. And I'm glad that there's a process to review them. But in terms of practitioners employed in the public sector, I received a complaint of a doctor that had problems with the Gauteng Department of Health. A pay was withheld, so her fees were not paid. And eventually, when the payment was restored, it was beyond, and she had to pay the exorbitant restoration fees. She came to me to say, but it's not my fault. And I said, you are the practitioner, you should pay. But arising from that, given the fact that the practitioner should be the one that takes responsibility for their fees, how does the council come to an agreement where employers pay fees on behalf of practitioners they employ? And when there are challenges like this, it is not the employer that is held liable for their administrative bungles. It's the practitioner that is held liable. So I just need to know how that gets explained. Because I accept the principle that practitioners should be responsible. So I need an explanation as to why you allow employers to take over responsibilities of practitioners, but when there are challenges, it's the practitioners that suffer the consequences. The second question is on the issue of recommendations for the health market inquiry. Is council protecting professional independence, or is it bowing down to the pressures from the market and business? The third question is 2015, there was a report given to the minister on unbundling by Professor Mayosi and the team that had been appointed by the then minister, Minister Aaron Motsoaledi, on that issue. I've been a chair of the MDB, and the MDB wanted to unbundle at the time that was there. What is the current position of the Medical and Dental Board on the issue of unbundling, and what is the position of council in that regard? Because if council can't protect the professional independence of the professions, all of them, including the medical and dental professions, then they probably need to go elsewhere to get that protection. The third question, the next question is about the jurisdiction of the HPCSA on non-care, non-clinical matters. Do you have jurisdiction on practitioners registered with you that are doing political or government work? I give myself as an example. I'm now a member of parliament, but I'm still registered with council. Now, if there are things that I do as a member of parliament in terms of my duty that has to do with legislation and other issues, does the council feel they have jurisdiction on those matters? If I have a misconduct in parliament, should I be reported to the Health Professions Council, or is it got to do with parliament as an independent institution which has its own ethics committee? And I'll give you a practical example of what happened. You have a case of Dr. Popira Matuba, who as the MEC of Limpopo was reported for doing duties as the political head of health, which had nothing to do with patient care, where a biased video was presented when she treated the patient with utmost respect, but when there as a political head, was reported to council and found guilty. That's why I'm asking on this issue of jurisdiction over political or other work that have nothing to do with patient care. And again, I guess the case of the UN rapporteur would fall into that category. It is quite ironic that both of them are black females. But I would like to know, because it means if I am able to continue to do my work as a member of parliament, do I need to deregister from council? Or can I be allowed to do this space because there's where I can account? Do we need to take this matter to the courts for adjudication? Or would practitioners registered with you be precluded from following other careers and working in international bodies like the UN? The next question is just can we be provided with more detail about the retirement of Dr. Masike? What actually happened? Has he retired? Is he still on the payroll? Are there outstanding matters with him? Can we please be fully appraised as to what is happening in that regard? Because I'm aware that his contract had not expired, and we just need an explanation as to whether there's an amicable separation. And if it was anticipated and amicable, why was there no advertisement for the registrar? Are we paying 2 salaries right now for the registrar position? So can we please have clarity on that issue? And I may have follow-up questions in that regard, Chair. I just need to be given clarity and more information with respect to that. Thank you for now, Chair.
Am I missing any other end? Not as far as I can see. Okay. On my part, these are the issues that I want to raise. There's a slide that talks about complaint process. And then in that slide, row 1, step 4. There's an issue that I want to understand. Can a practitioner appeal the decision of the preliminary committee on inquiry to the High Court? I'm raising this because there's a court judgment in which you were the appellants. It's in the matter between yourselves and one Sandrina Valerie Phillips, Phyllis Ludwig Heck. And I hope you are aware of that judgment. If you read this judgment in paragraph 39, the court said that the decision by the preliminary committee of inquiry to refer a complaint to the professional conduct committee is not appearance to the High Court under section 20 of the Act, as only the decision makers mentioned in the section are the final arbiters on any disciplinary matter before the council. Maybe you have got legal gurus there in the delegation, Prof, as the president. Can you then maybe you need to educate us about the circumstances under which a decision of a preliminary committee of inquiry can be appealed at the High Court? I've managed to read section 20 time and again to understand that. And I further read the Act as I proceeded, because from where we are standing, the only decision of a preliminary committee of inquiry that can be appealed at the High Court is a fine imposed for contempt of counsel, as the guilty finding of contempt of counsel, and then its penalty, then it's of immediate force and effect. Then I've gone through your slides 8, sorry, my apologies. Then I've got a following question. Can you then explain to us why there is a decline in performance at both mediation and investigation? Have you investigated why such a decline? Is working from home not affecting the performance of employees? Then I've gone through your slide 9 as well, wherein you are dealing with a professional conduct inquiry matters that are above 11 months. On average, how many matters are referred to professional conduct inquiry per year? And on average, how many matters do legal advisors or pro forma complainants finalize per year? Finalized per year by them, those people that you hired. Somebody asked that question earlier. I just wanted further details to that effect. Then when you look to slide 11, whenever we have challenges, we always think of adding more human resources. Do you think that your current human resources are fully engaged, that they are not able to clear the backlog? And that's the time wherein you also lose consultants to that effect. So I want to understand that, because since you have been there, I was told when I wanted you to come to the meeting that you were on a strategic retreat. So definitely these are the matters that you've considered. Looking at slide 13, this one is linked to my first question where I refer to paragraph 9 in your matter and the heck. Are you sure that the decision of the preliminary committee of inquiry is appealable by the complainant at the High Court? Then the other issue that I want to also emphasize, the issue that has been raised by Dr. Letlape. Do you have a company secretary or someone responsible for governance in the HPCSA? If you do, can you then explain why the names and terms of the council, which was inaugurated in December, has not been gazetted in the government gazette in terms of section 5(6) of the act? Maybe let me help you. I've been reading the act. It reads as follows. The names and members, that's section 5(6). The names and members of the council and the date of commencement of their term of office shall be published by the registrar in the Gazette as soon as possible after the constitution of the council. So can somebody talk to us about this non-compliance? Then the issue that I also want to raise in terms of the employment, I want to understand which categories of employees are on fixed term contracts at the HPCSA, and who is responsible for that management of these employment contracts. And then I also further want to understand how many months before the expiry of a contract do they either extend or renew a fixed term contract or advertise the position, as Honorable Leklape has said. In that regard also, whatever you will respond to us, then I will have a follow-up question to that effect. And then the other issue that I want to also understand from you, who's responsible for the terms of reference and their committees of the council? And where the terms of reference of the committee of the current council approved by the council or by the registrar? So these are some of the issues that I will have follow-up questions, but for now, I want you to quickly talk to them. And then you are aware of the issue of Mr. Twala. Somebody with the institutional memory, you are aware of the issue of Mr. Twala, who has since returned to us as the committee post our meeting, even in that meeting that we held with you late in November. This matter of Mr. Twala was raised, and then Mr. Twala is on record that he's not happy with the way that you've dealt with this matter. And then the worst part of it, I want to understand from your good selves, how do you then advise a complainant like Mr. Twala, who's unemployed, to approach the High Court, whereas there is no provision for that in the Act? So these are some of the issues that I want feedback from you for now. The other matters, I should think I will then be able to follow up based on their responses to this matter. And then there's the issue that Prof, as the president, I want you to also consider. As we have indicated, and this is a matter that is of concern for us, we had an engagement with them. We have asked them, as Honorable Chiroy said, to give us responses in writing within 7 days, which they failed to do that. As I've indicated, as we progress post your responses, I've got names of the people who were in the meeting who are still the officials of the council. And then I would like to know what remedial actions are you going to take against this personnel? And I also want to understand whether Ms. Padayaki, who then was the head for legal and regulatory affairs, is still an employee of the council or not. So these are some of the questions, but I will be able to share with you, Mr. President, the other officials who are in this meeting and they know themselves. The registrar also then that they are misleading us. We have raised questions with them, and then it's shocking to learn that our questions, some of our questions are not adequately responded to, and some of the answers is misleading, as Honorable Chirwa has said. Honorable Mutubatse, your hand is up.
No, Chair, I'm very disturbed, and I missed this point that Dr. Altapi is raising around the departure of Dr. Masike. And maybe the minister will be in a better place to can assist us in that regard on his departure. What are the reasons why he was offloaded of the institution? Was it around performance, or are there any other matters that are involved that the minister can take us into confidence in that regard, so that we can, because the honorable thing that could have been done was that at the beginning of the meeting, we could have been told that this is what happened with the institution, and therefore I forgot about that matter. But Honorable Klape is helping me. So if maybe the minister can take us into confidence as to what transpired in the change of guards, in particular with regard. Thanks, Chair.
Maybe before the minister can respond to that, but let me also assist you. For some of us who read court online, and I'm interested in labor-related matter, Honorable Mtovatsi. When I was reading his matter, I will tell you that in the facts of the case of Dr. Masike, Dr. Masike was appointed in May 2023 at the age of 62 years. His contract stated that the terms of appointment is 5 years or until he reaches 65. Yes, whichever comes first. Then it's common cause that Dr. Masike turned 65 on the 10th of February 2026. And then in terms of what the provisions of the Act, by August 2025, because they knew that he's going to be turning 65 on the 10th of February. This is a matter I raised in the last meeting. It means by August 2025, HR should have advised the then president about the expiry of the term of contract of Dr. Masike, so that Dr. Masike can be reminded, and then they then process the issue to recruit a new registrar, so that it has to be start that process. This was not done, and only in December instead of August, based on our meeting, that's when the new council was reminded. In fact, they was reminded by the National Department of Health that they need to start the process of recruiting the new registrar. If the department didn't do that, it wouldn't have happened. Then what I know in terms of the facts of the case that I read, then the new council, they opted to give Dr. Masike a 12 months extension while they recruit the new registrar. And then Dr. Masike took the council and the minister to court on an urgent basis. These are public documents for some of us who have got access to the court online. On an urgent basis, claiming that his contract it was for 5 years. The matter was struck on the roll on the 26th of February due to the fact that it lacks agency, and the HPCSA was awarded the cost. And then Mr. Masike has appealed the matter on the 27th of February. And then the other issue that I want to also understand from the current council, by December, the council was aware that Mr. Masike's contract is going to expire on the 10th of February. And then I want to understand why council didn't appoint an interim registrar, as Mr. Masike's contract ended on the 28th of February 2026. And what is more disturbing, colleagues, Mr. Masike continued to go to work and registering practitioners, attending meetings until the last day of Monday, the 16th of March, when Minister appointed Dr. Chetty as the interim registrar. So then the question that comes also, that I want it to be responded by both the minister and the council in particular. Who was the registrar of the HPCSA from 1st of March? Remember, the 26th of February was on a weekend, up to the 16th of March. If there was somebody then, was that person lawfully appointed? If there was no one, the issue that I want to raise, because it has got serious repercussions on the council. What about all the other activities that Dr. Masike did in the first half of the month? I want to understand whether they are lawful, and then if council can be sued, what leg are they going to stand on? So, Minister and the team and the President, those are the issues that we want you to respond to. Then the other colleagues, if they are not adequately responded to, they will come with follow-ups.
Chair, if I may start first, I just want to mention three things. The first is this contract of Dr. Masike, because it is said that he has been offloaded, etc. I think, Chair, you have explained the first part of it. Fortunately, when he was appointed by Dr. Joe Parker when he was a minister. He is the deputy minister now. So I consulted him all the way. As you are saying, Chairperson, in my understanding, Dr. Masike was appointed on a 5-year contract. As you are saying, I think in 2023, on a 5-year contract. The letter I've seen from Dr. Parker said you are appointed on a 5-year contract pending your signing of a contract with your employer, which is the Health Professions Council of South Africa. That contract was then written. And as you say in Chair, the contract says you are appointed on a contract of 5 years or until your retirement date, whichever comes first. And that is the key word in that contract, in my understanding, whichever came first. Both the council and Dr. Masike signed that contract, and he started the probation. After 1 year of finalizing the probation, Dr. Parker wrote another letter confirming the 5-year contract, meaning that the probation is over now, you can start your 5-year contract. But the part I don't know, Chairperson, which I can't vouch for or protect, is the part you ask about August, why they didn't inform him. Because this is what we do in our departments. That's why earlier on, I told you how I warned the HOD, the DG of Health, reminding him that his contract is expiring in May. So I thought they did it at the right time. I was not aware of the question you have asked about August. Maybe the council will answer. Now, when the date comes, Dr. Masike did phone me privately and told him that they are firing him from work. I then asked him, how are they firing you? Because from what I understand, you have retired, and the policy of the council is that people retire after 65 years. Then I called the president, who is here in the meeting, to have our meeting and understand exactly how they are handling this issue. And he told me that they've had a meeting where they took a decision that because there's a new council, they do not want to have a new council and a new registrar. If Dr. Masike could be extended by 1 year, that is what the president said, discussed with me. Before that could happen, as you said, Chairperson, Dr. Masike went to court, taking me and the HPSA to court, whereby I told him, I am not a signatory to that contract, so I cannot respond. I actually, the council asked me to write a confirmatory affidavit, which I declined. I said I cannot write an affidavit on this matter. It's a matter between employer and employee. And I'm an outsider in that process because the employee is the council after signing the contract. So the matter went to court on an urgent basis. And of course, it was struck off the roll by the council. Now, Chairperson, the question you are asking, why there was a delay, why there was a vacuum, you are right. This is because the council, instead of taking their decision as an employer, they throw it over to the minister. They wrote me a letter to say I must confirm the termination of the contract of Dr. Mashiki. I must confirm his termination, which means I'm the one who's terminating it, and I must put it in writing that I'm confirming the termination, which I declined because I told them that I am not a signatory to the contract between the council and Dr. Masiki. So I've got no local standard to terminate it. Whether you call it termination or a floating, I don't have any local standard. So I declined to do that. The council then, I understand, had another meeting. And Chairperson, I still want the council to clarify because I too was told that Dr. Masiki was in that meeting after the date of termination of his contract. But the president later told me that no, they asked him to leave. I don't know what's the truth about that because you put it on the table. I'm sure it will be answered. In which the council had another meeting because I then asked them to, as is always the practice since I was a minister, was that when they appoint a register, they advertise, they interview, they choose 3 people who they believe are suitable and send the 3 names to the minister. And the minister can appoint any one of the 3 names because all 3 of them are supposed to be suitable. Now, that is what the letter I wrote to the council to do, to say they must send me at least 3 names. The meaning of at least was that it should not be less than 3, because that's the practice I found being practiced at the HPSA since I became minister in 2009 and then came back again. I found them in that practice. So I said at least. They gave me 7 names, not 3, because they said I said at least. At least. Whereas I was meaning it must not be less than 3. But anyway, the president and Dr. Anban Pile, who is the DDG responsible for these entities, regulatory affairs and entities, they said and shortlisted. And in the shortlisting, they gave me 3 names and put them in what they regard as an order of preference or an order of priorities, and the 3 names. One of the 3, the people on the 3 names, I understand, declined and said it's not available. So only 2 could be appointed. And out of those names, I appointed Dr. Kemicheti, who is here today. In the order of their preference, she was number 1 on that list. So it is true, Chairperson, that during that process, there was a vacuum. And the vacuum was caused by the fact that the council did not want to take a decision that belongs to them. They, according to me, were hiding behind the minister to come and say, oh, the minister terminated the contract. A power which I do not have legally, Chairperson. Now, the issue of going to court, the argument from the lawyers, because I saw those papers, because I was cited, was that Dr. Pasha, when he was confirming the end of probation, was virtually giving Dr. Masike 5 years. And my argument, even a legal advice, which was sought by the council itself, said so, that the main relationship between an employer and employee is the contract they've signed, not any other letter written by anybody. A contract, every worker, especially at that level of executive, has to sign a contract. That contract is the one that guides the relationship. Any other document is irrelevant. And that's what the legal advice was saying. And I believe that's why maybe the matter was thrown in court on the basis of lack of agency. But I think it will be enrolled. It will still be enrolled if Dr. Masike so chooses. So to say that we have offloaded him and all that or terminate his contract is simply not true, Chairperson. I want to summarize it. The contract which I've seen, which he has signed, Dr. Pasha even told me that he personally asked him why did he agree to sign such a contract if he's not in agreement with it. It clearly says you are appointed on a 5-year contract or until you retire, whichever comes first. That was the cash weight, whichever comes first. And unfortunately, retirement came first before the 5-year end of the contract. That is the first thing I want to say, Chairperson. And I am made to understand, rumor has it out there among some doctors' groups, etc., that I fired Dr. Masike, and the social media said I fired my own friend, etc., which is very unfair. I am not using friendship, Chairperson, when I'm dealing with state issues. I can't use the issue of friendship. It is true I'm used to Dr. Masike. He was an MEC for health in Northwest. When I was a minister, I used to work with him. But here I was simply following rules, and the rule here is a contract between an employer and employee, which is the one that guides the relationship. The second thing I want to say, Chairperson, I do agree with the committee here because I was also distressed. But at one stage, I was intending to address the council because I did address them in the past. Dr. Letlap will remember when he was still the president of the council. Very worried. I am also worried about this issue of taking people to DC for things that are outside patient care. I still don't understand that. And privately, I did ask, because, Chair, I can't interfere in disciplinary actions of the professional, rather, conduct of the party because I can't, of the council, because it's a statutory board which is independent. I can't go to them and say, why don't you charge Aaron Mutwaledi? Why do you charge this one this way? Why do you sentence them? But I thought I'll go and understand the council. Why are they charging people for things which have got nothing to do with patient care? Because I thought it's professional. I was told, but this is not in writing, so it's informal, that no, the people who are being charged have been swearing and all that. And my own answer was, I've had many doctors swearing, but not ill-treating patients, just to swear. And so I agree with Dr. Letlapi that things that have got nothing to do with patient care, if you do them, what must happen to you? I, too, Dr. Letlapi, was registered with the council as a minister. And obviously, I'll say things politically in terms of politics. Unfortunately, when I left to Home Affairs, I did not register because I thought maybe it's not directly relevant. When I came back from Home Affairs, I wanted to register again. And the fees that they've quoted for me, I just simply don't have that money. It's thousands and thousands. And if I have to register again, I must go and break the bank. So unfortunately, I'm remaining outside the registration helm, but I'm just like Dr. Khosile Tlhapi, as a politician and a member of the profession. Only that I'm outside registration, not because I don't want to, simply because I don't have the amount of money they are looking for. So this issue of charging people for work other than how they took care of patients, for work in other, what do you call, in other from other political positions, it also surprised me. And when I addressed the council, and I was intending to, I didn't go to address the previous council because when these issues arose, they were already leaving. And I thought maybe it will be a waste of time. I must wait for the new council. But they had to go through all these problems. The last issue is the issue raised by Dr. Letlape, which I also agree with. I am the one who appointed a team of 5, which was chaired by the late Professor Bongani Mayosi, to review the council because I was worried about its performance and the manner in which they are doing their things. Because these things you are raising there are here today, are not starting today. They've been there even when I was in health for the first time. I then left, went Home Affairs for 5 years and came back and found them actually worse. I must tell you, I believe they are worse than during the time I put Professor Mayosi's report. That report was implemented, as you know. The only part that was not implemented was the unbundling. Because, Chair, what is this unbundling? Professor Mayosi clearly stated that part of the dysfunctioning of the council is the way it's constituted, Chairperson. Maybe I will explain to you what that means without undermining other people. Before 1994, we had South African Medical and Dental Council, the council, which was only for dentists and doctors only. That was pre-1990, the South African Medical and Dental Council. Now the new council is called the HPCSA, the Health Professions Council of South Africa. It consists of many other people who are health workers outside the health outside the medical and dental profession, but who are just health workers in other fields of healthcare. Now, the surprising thing is that the nursing council was left intact. It consists of nurses and nurses only. There's no other profession, it's a nursing council. The pharmacy council was left intact. It consists of pharmacists only, there's no other person. But when it comes to medicine and dental, then they changed it and added many other people. Then it was divided into 12 boards, which is the medical and dental board that represent the old medical council. Then from there, there's a board of physiotherapists, a board of this group, a board of that group, and a board of that group. When they combine, they form the council. Now, Chairperson, that type of structure is dysfunctional because we have got people here who have got different interests, different levels of training, and different job description, having to sit and form a council. And I want honorable members to understand me. I'm not undermining people. This has happened before. If you know, there's a union called NEHAU, which was formed before SADU and DINOSA. NEHAU takes everybody who is working in education, working in health. That's why it is Education and Allied Workers Union, etc., etc. So there will be a clerk and a professor and a teacher and a doctor and a nurse and a driver and all that, whose interests and job descriptions are quite different. The teachers saw it first. That's why they pulled out the form SATU. The nurses realized it later. The form DINOSA. I'm just giving an example. Now, in the Health Professions Council, this is the problem, Chair, as outlined by Professor Mayosi. We have got the EMS, which consists of people in emergency medical services. Some of them have trained for only 6 weeks. That is their training. Then you have got a professor or a specialist whose minimum training was 13 years. And this person who trained for 6 weeks not understanding issues, must sit and take a decision over somebody who has got a training of 18 months in a completely different professional level. And Professor Mayosi said that's why this is not working. So he asked about the unbundling. Of course, the situation became better because it was also numbers. There's an issue of numbers where they are voting. And the EMS was the biggest group because it consists of a majority of people who only train for 6 weeks. So they come in large numbers. Of course, they changed the rules and upgraded and said only those who train for 1 year as EMS will be members of the council. So they just cut to 1 year. But the effect, even though are not like originally with 6 weeks, the effects are still more or less the same. So seeing that, Chairperson, I called all the structures in this profession. I called South African Medical Association, which is an association of doctors. I called, I'm just quoting it because it's very much well known. I quoted quite a number of professional groups and unions, which are not which are not necessarily part of SAMA. And I called the deans of medical school because this matter affects them. The deans who are attending medical schools where training or specialists, etc., is taking place. We had a meeting and I told them, I would like to go and dust Professor Mayosi report, which has been put on hold for 5 years. I want it to come back and we must implement. Everybody has agreed. I don't know anybody in the profession any longer who is resisting the unbundling. I've asked the DDG, Dr. Anban Pile, who is responsible for this, as I said, to form a task team of all these organizations so that we move over to unbundling. And what does unbundling means? It means the former medical and dental council must come back, whether you give it a different name. That's a council for doctors and dentists. Then the rest will form the council, the rest of the boards. That is exactly what. But the war here was that it is the medical and dental board, which is equivalent to the previous medical council. They say they are the ones who have got a big financial power because it consists of doctors and dentists. But now we cannot have a structure as important as this dysfunctioning. It is dysfunctional even now because under the conditions I've mentioned, people take sides. And all that those who are senior chairperson are concerned, they just go and mobilize and say, if I'm in, this will not happen. If you appoint me, this and that will not happen. I saw it during the nomination process when people were phoning me privately and say, no, please appoint me. And I said, no, I depend on the name from members of the profession. Because remember, Chairperson, we are not funding. The government is not funding this council. It is funded from affiliation fees of their own members. They don't get any budget from us. So we do not nominate them, but they nominate and bring it here, and we ask them questions. If the person doesn't qualify, then we challenge them. If he qualifies, then we have got to sign them on. That is, those are the three things I want to raise, Chairperson. So the disbanding is definitely going to happen because members of the profession, all of them, are saying it must be, if the disbanding does not happen, this council will not be functional. And they will come to you again and again and again, Chairperson. That I don't want to lie to you. Even the manner in which the issue of Dr. Masiki was handled, apart from the fact that I mentioned the contract and its validity, but the manner it was handled, you could see this dysfunctionality. I could see it. And that's why the president should confirm that I called him and said, but why is your council working like this? Why are they hiding even on things that fall within their sphere of influence? Why do they want to hide behind the minister and say because he's the one who appointed, he's also responsible for contracts, when you know that is not the case? So, Chairperson, those are the things I want to mention. The rest, I think they are in a position to respond to. Thank you.
Thank you, Minister. President, start with the issue of the former registrar before any other issue.
No, thanks a lot, Honorable Chair. We come in as a new council. On the first day, we are presented with the information that the registrar's employment contract is supposed to be reviewed because he's retiring when he turns age 65. That correctly so, as you have said, that information is shared via the National Department of Health, and we are provided with the relevant information as far as the contract is concerned. From that moment, we acted according to our view swiftly and convened the necessary structure that manages the contractual performance of the registrar, which is the EXCO of Council. In that process, obviously the contract is reviewed, discussed by members, and members must determine if the registrar should retire or continue with his contract. Out of the discussions, we agreed to seek a legal opinion, which led to a need for a supplementary opinion. And the main recommendation of that legal opinion, which was later considered by Council, said, according to the employment contract between the registrar and the HPCSA, Dr. Masige should retire upon attainment of the age 65. There is a term used in the opinion called automatic termination upon retirement. The interpretation of that is that it is not a dismissal, it is automatic termination because of retirement. And our job was then internally, according to our practice in the HPCSA, to notify Dr. Masige, which we did. The requirement is that we must notify him, within 60 days before the actual retirement date, and by definition, the retirement date, I think his age was turning 65 mid-month. It says by the end of that particular month, he will then retire. So he was notified from that point of view. Alongside that, we then needed to inform the appointing authority. According to the Health Professions Act, the appointing authority is the Honorable Minister of Health, which we did. The issue is that between the appointing authority and the employing authority, which is the HPCSA, then we needed to clarify issues in order for the appointing authority to make a determination of the status of our position. What was clear is that the position that we have taken is a policy position of the organization. The decision is based on the policy of the organization, and therefore we needed to follow processes to request the Honorable Minister to make an appointment in an interim basis while we are looking at filling the post. So Minister has covered several aspects of this particular process that we needed to follow. I must admit it was not an easy process on two fronts. Inside the council, dealing with an issue of a CEO or a registrar is not an easy matter. It was a contested matter, but following procedures of the council, we were able to make decisions, albeit with some turnaround times delayed in terms of making sure that we are able to, by the 1st of March, to have an appointment made. That meant that we rely heavily on the decision of the appointing authority, because the council felt it is not an appointing authority. We have done enough to notify the appointing authority that there is a need for an appointment on an interim basis and for measures to be taken to make the appointment. we ultimately arrived at an appointment, as Chair has rightfully said, on the 16th of March. So that's the process that we have followed. What happened after the end of February? Dr. Masike was notified, that he is no longer the employee. He has retired, so he was aware of that. I am told, that there are committees that he pitched. He attended the meetings despite being informed of that. I would not argue or understand on the basis of what he reported for duty, but as a council, we had a firm position that he has retired, and according to us, he has retired. We cannot take away his rights, to challenge decisions or seek recourse in order, to be assisted by the courts of the land. That process, we have said as a council, we will always subject ourselves to the rule of law. So that's, I think, that's where we are now. We've got an interim registrar. She's about a week on the job, and she is continuing with her work. There was a question, I think, from Honorable Letlape, whether we're paying two salaries. According to my understanding as the president, we've got one registrar, is an interim registrar appointed by the Honorable Minister of Health, Dr. Chetty, since the 16th of that. I am not aware that the council is paying two salaries. What I know is that we've got one registrar, and the delegations have continued to be implemented as per council delegations to the interim registrar. So that is where we are in relation to this matter, Chair. I would like to then proceed to talk in respect of the remarks from Honorable Chirwa. And
before that, so that we close this matter, President, you are also on record said that though you have told him that the contract has ended, he continued to attend meetings. You are told so. And then the question that I raised also, that signal that he continued to come to work, and that means he might have also registered practitioners until the last day of the 16th of March, when Minister appointed Dr. Kamicheti as interim registrar. So there are issues there that you are not attending to, because then for the period of 1st March up to 16 March, how do you account for that? And then definitely there was no one. And then what about the activities that the former registrar performed during those days of the month until when the minister appointed the Dr. Chetty? How are you dealing with that? And then the other issue, so that we also deal with that. There's an issue here that indeed, like I indicated earlier, if the department didn't tell you that you must start the process, there's an act. And then there are people who are employed there who are also legal advisors to the council, whom they should have done this by August. I even raised it in our meeting with them in November. I want to know what steps, what consequence management are you going to take for these employees who have failed to do their duty? They are hired there with the requisite qualifications that they must do their work. They need to comply with the law. You see, I need to emphasize this, President. You are a creation of the statute, an act of parliament, which is the Health Professions Act. And then, you see, hence you are here now. And we are calling you because you are empowered by this law. That's why we are holding you accountable. But when there are rogue elements within your institution who neglect to implement what the law is saying, and now you are here, you are given an opportunity to respond, you say nothing even about what steps are you going to take or whatever. Honestly, I want you to talk to us to that effect, Mr. President, with due respect.
No, thanks.
Chair.
I've given you an opportunity to speak.
Oh, all right. Myself.
Oh, sorry, it's you, Mr. Honorable Mtubazi, before the president responds. Yes.
No, Chair, you
It's
see,
still on this matter of the
yes.
registrar. Yes,
No,
proceed.
Chairperson, we are not dealing with personalities here, and I must actually be clear and caution the minister that we are not dealing with issues that are on the sidelines. No, the issue that he raises that no is because this is what is happening because they are friends. There's mobilization outside. We're not worried about that thing. We're just dealing with issues of principle because we are the guardians of these institutions as members of the portfolio committee. Now, the president raises the issue of performance, but he doesn't tell us and about the question of performance, what actually happened. This is what we credit him. He quickly runs to the question of age. Now, my question is age the determining factor that made the council to arrive at a decision that they've arrived at, so that in future we must not have a problem? And also, if age is the determining factor in this regard, the current incumbent, if that is what informs the employment, we need to get into that particular and everything be laid on the table to say, no, look, we considered because young people are out there, they are not working. This is we arrived at a decision to say the age, therefore, we are cutting at this age so that we can give the longevity of people who are going to be occupying that particular position. But I'm just citing those issues because these issues are quite disturbing on what the minister have said. And but I think there's much that meets the eye regarding what is happening in the institution. And the minister have summarized it. I think there's a lot that we need to look into. I don't know whether we'll be able to look into this particular matter currently, because we might actually go into the other night dealing with this particular matter. I'll suggest, Chairperson, that we look into the questions that we have raised, but specifically, we then arrive at a decision that says we need to come back to this particular matter specifically to look at what transpires so that we can clear ourselves so we can understand the nitty-gritties of what happened around this particular matter. Thanks, Chairperson.
They are clear, straightforward questions that they need to respond to. Now, the questions raised by Honorable Shiro, the direct question, Honorable Clark. In fact, all the questions, that which will be a way forward on what you are proposing, but there are questions that are directed that needs to be followed up that they need to respond to now. On that one, Honorable Mtubatse, can they proceed, President, respond to our issues? Then you'll give the others the opportunity to respond to the other issues.
No, thanks a lot, Chair. We note and take seriously the feedback raised by honorable members. To start on the question of performance versus age, the discussions that is about Dr. Masike is about an employment contract that was signed between the employer and the employee. And it has got a clause that we have verified legally that we need to comply with that employment contract in line with the HPCSA policy. It is not a performance issue, it is an employment contract issue, Chair. The second part is the question that what has happened after the 28th of February. which meant that Dr. Masike participated in some of our activities. As a council, we have got an interim registrar who is the CEO of the organization. Part of the work that she has to do for us is to check what happened after the date, audit all transactions signed, approved or not approved, and from out of that she has to come up with a plan to mitigate in terms of risks to the organization if Dr. Masike signed or approved any significant transactions on behalf of the organization from that. So that work is on, and she will advise council accordingly on the best way to handle that. The second part of the question from the Honorable Chair says, why did we wake up so late and act so late on this matter? We are a new council, Chair, and the matter was put on our table and we worked on it. We are not happy with the period that it has taken to get to where it is now. But as a new partner in the process, a new council in the process, we have to check where did we get it wrong, what was the problem from the governance point of view. Again, the registrar will assist with that together with the company secretary to advise on what happened and what do we need to do in order to mitigate in future. Now, the registrar is delegated to ensure that there is discipline in the workplace. If out of that particular process there is a need for disciplinary action, or we've got evidence for us to act, she will have to activate that particular process with consequences proportionate to that particular process. So that is I think where we are now. We appreciate the concerns and we take them seriously, Chair. The concerns that you are raising, that from a governance point of view, there's been a lapse, and the lapse that has exposed the council to serious challenges. But we are working on it, and we promise we will improve on the situation, and where necessary, consequence management will be implemented. If you allow me, Chair, I just wanted to touch on the remarks by Honorable Chirwa before I hand over to the registrar to answer some of the specific questions that were raised by the honorable members. I want to say to Honorable Chirwa, you have heard that our Honorable Minister himself is concerned about the state of the Council, its work, and he is concerned that according to him it is dysfunctional. As a new Council, we acknowledge that the state of affairs is not at its best, and we are attending to the matters presented in front of us. We would not want to be here to lead a council that is perceived in the manner that you have said. We believe that the HPCSA draws its mandate from the Constitution of the Republic, the policies of the Republic, and it's important for us to guide it back to its rightful path. Yes, there have been some areas of improvement over the years, especially after the Mayosi report. There have been turnaround strategies implemented. But those turnaround strategies are proving not to be enough, and therefore we must continue to find innovative ways to serve the population and to serve the professions. You touch something that is of concern to us, that we seem to be operating as an apartheid HPCSA in the New South Africa. I think that's how I got to understand you. I want to assure you that as this council, we will not be able to accept an apartheid HPCSA because it will be unconstitutional. It will not be based on the laws that are guiding the work that we are doing, and we commit that we'll do our best to guide it in the right direction to focus on its mandate. There are specific questions that you touched on in relation to, I think also Honorable Mtubase touched on it, that we did not respond to questions that were sent to us as the council, and we now come not ready, still investigating alternative ways to respond and confirm the work that we are doing. I want to say we are performing regulated functions, and as performing regulated functions based on peer review and the law, we have to manage them in a particular way so that at the end of the day, the integrity of the process is always maintained. I know that you are concerned about our pursuit of that process in relation to some members of society. I heard you talking about black professionals. I heard you talking about relationship to funders. I heard you talking about other aspects, that definitely as HPCSA, we are not allowed, to partner or collaborate with things that can influence us not to do our job. As far as I know, the processes that we are undertaking, especially under the Medical and Dental Board, the integrity of the process, I think as professionals we try our best to ensure that that process is followed. Yes, it can be challenged. Yes, it is not perfect. Yes, it has got a huge turnaround at times, but we are working tirelessly to ensure that it is fair, it is transparent, and it does not victimize practitioners or patients or community members. So that process we are on. You're talking an important point that as much as we are looking for a legal opinion on a matter of this nature, why did we leave it up to now? I'm not a person who likes giving apologies and excuses, honorable member, but we also take note, of the advice that you have given in the course of your remarks in relation to consultations, in order to make sure that we are able to deal with this matter. But more importantly, not only deal with it now, but learn on how to deal with matters of this nature and ensure that the lessons from this matter of this nature make their way into the policy framework or procedures that we use so that we are able to be fair to our practitioners. So without wasting time, Chair, if you allow me, I would like to hand over to the registrar, just to assist us to go to some of the matters that the honorable members touched as well.
Dr. Chetty, are you ready?
Yes, thanks very much, Honorable Chair and honorable members. Chair, maybe if I can also just start off with the issue around the legal opinion. As has been indicated, I've been interim CEO for the registrar for the past week. And so one of the things that I had to do was to look at what actions had been taken and what are the additional actions that needed to be taken, with regard to this issue and other issues. And so I asked the question, has there been a legal opinion? And when I was informed that there wasn't, I can't comment as to why it hadn't been received before, but we immediately took that corrective action. I've also asked for all decisions taken during that 2-week period so that I can look at what needs to be done, either to regularize it with registrations or whatever, but I will be scrutinizing, everything that had been signed off during that period. So I've already done that. Chair, I'm going to ask that, and very briefly, because I think it'll be important that there's a number of questions that have been asked, and we will respond in writing to those questions. But I'm going to ask the acting head of the legal services to respond to the issues around the complaints. There was a specific question around Ms. Padiachi and whether she's still within the employ of the HPCSA, and she has left the HPCSA as at the end of February, and Ms. Kwena Mabasa is acting in that position. So I'm going to ask her to just respond to the issue of the complaints. Thanks, Chair.
Good evening, Honorable Chair and Honorable Members. I think maybe first going to the question relating to jurisdiction. One of the key issues that was mentioned in the grief judgment on paragraph 10 is talking about unprofessional conduct and how broad the definition is, and that nothing in it supports the contention that the Council's jurisdiction is confined to the conduct of rendering of health services. So because of the broadness of the definition of unprofessional conduct, that is why we will deal with matters which not necessarily involve practitioner-patient relationship in that regard. Which would have explained why we will then look at whether the practitioner is registered, and then we'll move from there. In paragraph 12, it further just indicates that Council is not merely a medical malpractice watchdog, it's also the primary guardian of morals of the health professions, and further quoting the case of Predi. Today, when we were in the session, Council, as one of their priorities, is to review the Health Professions Act in its own, entirety, looking at some of the issues that have been raised in terms of issues emanating from the Act. Just going to issues of transparency in terms of reporting. We do reflect on the trends of complaints in the annual report. However, we do take the suggestion that is coming from Honorable Dubati about maybe having the dashboard as it relates to the performance and the trends relating to complaints. The issue of the turnaround time, the true turnaround time, based on the information that we do have, matters at mediation in terms of our true turnaround times are currently finalized around at an average of 47.5 days. This is in accordance with our Q3 report of this financial year. And in terms of matters at investigation, on average, matters have been finalized around 102 days. We are aware that we do need to have some improvements in other areas. And in responding to this, I also would like to respond to the issue of why the decline in the performance in mediation and investigation as the years were going by. And that was attributed to the increase in terms of the complaints that we have seen, where in 2023-24, they went to 17%, and 2024-2025, they went to 24%. I further just wish to add on that we have continuously been reviewing the capacity in terms of the human resource to deal with the complaints. And in 2023, we had additional 3 positions created wherein they were filled in 3 consecutive years, especially at investigations, as the numbers were rising there. In terms of the independent or oversight mechanism, there is Ethics Committee of Council, where the reports relating to the performance and also the trends are presented. And the system, we cannot say that it has been audited, but so far we can say that it has been accessible to members of the public. We are aware that for some members who are in deep rural, they might not be able to access the system. That is why we have still left the options for the forms to be completed and sent through to us. Some of the members of the public, they also utilize the inspectorate regional offices, which we do have in Durban, East London, Cape Town, and also Pretoria. What are the steps that have been taken to standardize some of the sanctions? The boards, especially the currently appointed board members, have taken this as some of their strategies to ensure that there's no discrepancies in terms of the sanctions that are imposed by the different preliminary committees of inquiry. In terms of conflict of interest, when members of the committees meet, the first thing is that they are informed that if there is conflict of interest, they must declare, and those that declare, then they are recused from the meeting, so that the process is fair in that regard. Where do the complaints originate, whether urban or rural? We do not have the direct data regarding that, but we do have data regarding 2 provinces. And most of our complaints are relating to practitioners, mostly in Gauteng and KZN, Western Cape, and the information is available in the annual report. In terms of whether the issue is just the staffing level or is it deeper than that, internally we are also looking at, as much as we have enhanced the system and we can be able to monitor and be able to see how many complaints are coming per month. We receive around 236 complaints per month. Further to that, what we are doing is in terms of, we are strengthening the case management system because we want to be able to pick up the efficiency as well. There was a question in relation to matters finalized by legal advisors. Throughout the years, in the previous financial year, I think it was around 158. With the 7 legal advisors, it works out around 33 matters to 35 that are finalized per annum. Thank you. Thank you, Honorable Chair and members.
Are we done, Mr. President? Because I'm just worried with the, before that, before somebody calls the chair, I'm just worried, especially the latter speaker. Our questions were direct, specific, but we are being told the rhetoric, this is how it's done, and our questions were direct. But let me give Honorable Chiro.
Yeah, no, I think the HPCSA, it really is just taking us for fools, honestly. None of our questions were answered. None of them. We asked Uguti, where did they get Igunya to go after a UN rapporteur when the UN clearly gives them immunity from domestic legal processes? This is a direct question. Tell us where you got that jurisdiction. Simple. We got it from this statute. We got it from this regulation that we can go ahead and penalize UN rapporteurs even if they have immunities to undergo domestic legal procedures. That's number one. Because I'm asking this because Aninalo, you don't have the right to do that, but you have done it. So that also must call for an introspection on your part. Secondly, I asked about the issue of engagement with DECO and the United Nations and the minister on the issue of the Tataleng Mufokeng. You didn't answer that. Thirdly, I asked you why you have not shared your reasons for your findings with Dr. Tataleng Mufokeng so she can prepare for her next appearance with you guys. You did not answer that. And I asked you what tools of analysis did you utilize to find her guilty and also to sanction her in the way that you have. You did not answer that. I also asked you why you did not grant a postponement. She won't be in the country on the 9th and the 10th of June. I even cited your presentation, which you are lying to the portfolio committee, saying that you agreed with both parties to continue in June, which is incorrect. It's a lie. She appraised you that she won't be in the country, and you decided by yourselves that you're going to continue whether she's there or not. I asked you, why did you do that? Because you are denying her a fair opportunity to come and present her case, and on two levels. Firstly, you're not giving her the reasons on why you found her guilty and why you sanctioned her the way you did. And then secondly, you're not giving an opportunity to be available on the day that you're going to discuss this further. I'm asking you, why are you doing that? You're not answering that. And then, lo muntu obekhuluma manje, anischazele bandla. In which capacity is she responding to this particular question? Because manje kuzomela ukuthi sinibuza ama-question adi, because the way niphendula ngakhona iyacaca ukuthi anazi ukuthi ngikhuluma ngani. Please appraise us of the previous speaker ukuthi what are her qualifications, when they were obtained, and what she serves as in the HPCSA. And then lastly, President, please, you'll have to go back and review this case. I'm saying this with utmost respect. The integrity that you're speaking about, that you're trying to maintain or work around of the HPCSA, is already destroyed. I don't know if you're realizing what this engagement with the HPCSA has done for the institution in this particular meeting. NHLSA was here, CMS was here, and even those two entities, with the problems they have, it's not at the magnitude that HPCSA is currently having. And you guys can't just take it as another day where you can just run around our questions and give us rhetoric and vague answers. You cannot pendulate my question because they are very specific. Answer all of them. And you will write back to us. You won't do that. You are not given that grace anymore because we gave you that grace and you didn't do it. So please answer our questions. As Dlalila, if it means you must leave after midnight until you answer our questions, we will do so. These are whys and hows and whats questions. You can't give us answers that have nothing to do with what we're asking. They are specific. They are in relation to specific cases, like the one we discussed about Dr. Masike. You are able to respond to that by naming him. But manje, now you are being mum. You are giving us answers that are hovering in the sky. Why? Why are you doing that? Please respect this portfolio committee, respect our proceedings, and give us the answers. As Lal.
Thank you. Dr. Litape, over to you, colleague.
Thank you, Chair. For me, the issues that I raise about other officers is important. And if the HPCSA's answer is that it has no respect for other officers, other jurisdictions, and it's got absolute power over the practitioners that register over it, irrespective of what they do, it means that, Minister, we have to urgently review the powers of the HPCSA and the law. If they are going to exercise their powers recklessly, we need to ensure that they do not put this country into distress, where we are now signatories to the UN and we do not respect the processes of the United Nations. That is a serious, serious issue. That as a parliament that believes in multilateralism, that is part of those global structures, and you have an entity under our statutes that feels it does not respect those issues of jurisdictions and immunities that are conferred by international bodies where our government is a participant. requires urgent attention, Minister, in terms of reviewing the act and sorting that out. And I accept the fact that there's an interpretation from the court, but that interpretation is based on the statutes as they are written. If we are going to be part of multilateral structures, if we're going to be part of the global world, this requires urgent attention to sort out. So for me, Chair, I'm appealing to the committee, I'm appealing to the minister that this matter of jurisdiction is critical, because now the nation is not doing its job as a member of the United Nations to ensure that it upholds the protocols that the government has signed up to. Thank you, Chair.
Thank you, Dr. Letrape. I want to echo the sentiments of Honorable Shiro. President, when you said the team must respond, we're looking forward to get responses, especially the person who's the acting head, legal and regulatory affairs, because there are so many items of non-compliance here. And then we ask questions with the view that when you hand over to her, she will, with due respect, she will be able to respond to the questions. And our questions remain unanswered because this is a clear, the questions that I raised myself, the technical question that I raised, I was expecting the head of legal to respond. And then if we are casual on how we respond to questions, honestly, this is what we do in the organization. Can we then deal with this issue so that competent people are given responsibilities? Because I asked a question on whether a practitioner can appeal the decision of the preliminary committee. That is a straightforward legal question which somebody who's the legal and head regulator affairs person can respond to. But that question is never responded to. I raise a clear, straightforward question on the professional conduct inquiry matters that are above 11 months. I've asked how many matters do legal advice or pro forma complainants finalize per year. That thing was never responded to. Also, the circumstances, because the person that is acting, I definitely believe by the time when the contract of Dr. Masike was to come to an end, as a legal person, by August, it's somebody who must check the laws, the rules to say we have got this many types of contracts, this is what is going to happen, so that the council can be informed appropriately. That's why I'm saying, we still bring people here who can take responsibility, and as if now we are here, we are just with, it's unholy hours of the night here. And the reason why we call you, we want accountability. And I need to emphasize again, you are a creator of a statute. Because also this thing, our experience with you as Honorable Shiro is saying, because these are the same people that are your support staff, Mr. President. When we say respond to our question in writing, they don't do that. That's why at some point we'll want you to respond to our question either way now here, especially on the direct questions, specific questions that are direct. That's somebody who's a legal and regulatory manager must be able to respond. But those questions are just pushed under the table, under the carpet. We are not responded to. I'm still seated with the question, with the issue of Mr. Ndishe's complaint. See, registrar signed off the letter to tell us that the matter has been closed because of lack of evidence. And then you have some people who are in the legal department, whom they know that if there's insufficient evidence, they've got a responsibility to exercise their statutory duty to obtain evidence. And then they don't do that. They are just quick to close cases. But there are people who are highly paid, who are deemed to have been legally qualified. That's why I'll also agree with Honorable Chira on this matter. Maybe can we be given the qualification of this person who has been responding And if indeed he or she is qualified, when did she get the qualifications? What experience that this person have? Because honestly, you cannot continue with such an employee who doesn't even know what it's supposed to do. And this is critical in your area of work because you are regulated. So you need somebody who will be able to then articulate the provisions of the Act, articulate any other policies that are there. But we are seated here, we're just being told things that are common sense that don't exist. Honestly, with due respect, can we be respected? Minister?
Yeah, Chairperson, I was going to ask a similar question because I am also very worried, and I believe we're going to spend many more nights like we are doing today. I picked up something that is disturbing, and I want the president to confirm it. Is it true that your head of legal and regulatory affairs is not a lawyer? Because I've been in government for many years, 32 years now. I don't remember meeting anybody. I was in agriculture, I was in education, I was in transport, I'm in health, I was in home affairs. I don't remember any of those departments having a legal department that is not headed by a lawyer. So on what basis are legal, it now, Chairperson, explains something if it is true, which you don't know about. This council, before I inaugurated, we had very serious clashes. I even refused when people have already been invited. They came from all over the country. I refused to go inaugurate them because we're differing about a simple, what you call of the Constitution of Council, Section 5(1)(a). It's a simple thing. It says no more than 16 designated by the professional boards on a basis of proportional, blah, blah, blah. It's a simple thing. I don't want to waste your time to read it. We argued on its interpretation. So while I agree with you, Dr. Khosile Tlape, that we might have to change some laws, I want also to argue that in some instances it's not the law, it's interpretation. And I can tell you to interpret statutes when you are not legally trained. I am even better because I told them this is what this section means. And they were having arguments with me. I even went to my legal advisor, who's a senior counsel, and he agreed with me. And I said, is there a possibility that somebody who is a lawyer can interpret this differently? So, Chair, I am really appealing. Can the president answer this? If the answer is yes, please deal with this matter. I don't want to go and spend long meetings again. The second thing that scares me, this issue of morality, that it doesn't go through, your jurisdiction is not only through professional conduct, it's also through morality. That's completely uncharted waters. What is how do you describe morality? And who has got the right to impose morals? And what type of morals over? Is it church morals? Is it religious? Is it, no, Chairperson, no.
Minister,
We are in trouble.
Minister, those
No.
are your legal and regulatory affairs people in one of the council that you've got oversight on, Minister. Honestly, that's why I'm saying I think we are being disrespected to the highest order. Because then, I've raised a serious question here and then we were told about morality here. And then I've also, as they do that, with regard to the complaint processes, under the circumstances, who decide on whether the council has jurisdiction to pursue the matter or not? And we want to understand what are the qualifications of such people, and then who plays such a critical role that it affects the rights of really professionals. We're talking about professionals here to practice their profession, and also the interest of the public at large, because also members of the public are complainants who happen to be the patients of the health system. Honestly, Minister, I think that's the matter. If it's in hindsight, Registrar, if it's in hindsight, Mr. President of the Council, honestly, we need responses to that effect, because it's a problem. You cannot have somebody who said, what qualities do you look a person? Somebody is a head of regulatory affairs, legal, and then you come and people look, they come here like the minister is saying. He's not even a lawyer, but he can hear this reasoning, or it's out of order, uncalled for. I think the registrar and the president must respond to this, because there's no answers to all our legal regulatory questions that we've raised here. But you have brought somebody here, you are saying is the head of legal and regulatory affairs.
Thanks, Honorable Chair. I would like to hand over to the interim registrar to respond on most of the issues raised by honorable members.
Thank you, Honorable Chair and honorable members. Chair, a part of what I was doing during my tenure here is to look at the skills of the various individuals. And can I just say that we take the portfolio committee very seriously. So that's why the issues that you've raised, we've been looking at that and seeing in what ways it can be rectified. People have been acting in positions, and as part of that, we have to look at the capacity of the council as a whole, because we need to deliver. My understanding is that the acting, when I asked the acting head of legal, the background of the acting head of legal has been mainly in issues around quality. She does have a health professional background, and she's obtained her LLB, but my understanding is that it has been a short while ago. Those are all issues that we are will be in discussion with the council, and we will be looking at ways in which it can be rectified. So, Chair, I want to ask that we be given the opportunity, because the council has asked these questions, and that we be given the opportunity of looking at the turnaround strategy, which we can then come and which we'll be presenting to the council, and who will then present to the minister, and it's given the opportunity of implementing that.
There's a hand.
Chairperson,
You see, Dr. Chetty, as I allow the hand that is up,
as far
I think you are being misled in certain things, né? Because the incumbent is a physiotherapist by profession. And then she also just obtained her LLB last year. It means she obtained this degree while she's working. There's no legal experience there. There's no legal experience there. And you can hear by the way she says it. So the quality things, I don't know where are they coming from. That's why, but let me hand over to Honorable Mutawasi. You can talk.
Chairperson, I'm actually very irritated, just to put it blunt, because the minister asked a simple question: does this person have the qualifications? And you ask, where did this person go? It's a very straightforward question, and I don't think we can be undermined like this, Chairperson. And then someone tells us about the skills. We understand those things. I don't know.
Yeah, I think at some point I'll have to end this meeting here.
I don't know.
Maybe, President, we need to give you to go back. You'll have to come back. Because
No,
honestly, because there's the issue of Mr. Twala that I've asked. How he is, that's why somebody said you are like you are an apartheid HPCSA president. I was expecting this person to talk to the facts. Unless you just picked this person and say, let's go to the committee, and you were just coming here just to a malicious compliance matter. So it's a task to you, acting registrar and the president and the council. You've got so much work to do to turn around this entity. And this issue that the registrar is saying of the skill set and experience, maybe will give you a task so that within the next 7 days, you give us what are the skill set of these people, what legal experience if this person, especially on such a critical position. So there were no other people, or there were no other deserving people who can be given this responsibility. So I'm trying to be frustrated. There are questions that are pertinent. I've raised the issue of Mr. Njezi. I've raised the issue of Mr. Twala. Straightforward matters, but it also comes still to the same portfolio that we were talking about. That's why we're saying where we are, of the feeling that, Minister, we won't get any responses here. We will never find any truth here under the circumstances. And I realized that as and when we were talking, we're just speaking here. Nobody was paying attention to what we were saying, especially from the administrative side, because we were raising technical issues, which we were expecting the technical people supporting the council should be able to deal with the matters. So, and it's a show to say, you are so brave, if it's not disrespect of the portfolio committee, to just come here and lie to us. And then you think you'll just easily get away with us. No. We can't be. Because I think I need to also remind you, we are parliament. And I've emphasized that you are here by the creation of the statute. And that's why we are holding you accountable. So you see, we have got a mechanism, but we'll give you the last chance, because we have got rules 167 that we can utilize. Secondly, we have got the law that talks about contempt of parliament. And I need to remind you again, maybe every time when you appear before us, I will have to remind you that providing misleading information can be seen as undermining the functions of the parliament, and it constitutes the breach of privilege. And there are statutory offenses to that, Ms. Head of Legal and Regulatory Affairs. Ne? So it's a crime to provide false or misleading information to Parliament. I just want to leave you with that. We'll again resubmit our questions to you in writing. And there are issues that Honorable Shirwada urgent about Dr. Taleng's matter, because if somebody has said, I'm not available on these days because I've got this international responsibility representing the country, and you still schedule a case, then you are breaching her right to be heard in terms of the Constitution. And what kind of a legal person are you who, when somebody said, they give you proof, I'm not going to be available, then you still schedule a matter for hearing knowingly that that person won't be there? That's irresponsible and reckless trading, if I must say that. So we'll have to call you again. Maybe we should call you physically so that we look you in your faces. And this is the message I'm giving you, President, and the team. And the acting registrar, don't just believe anything that you are told. Because that's where we are now. And honestly, we cannot continue like this. I don't see any need, members, to continue with this meeting. I'm subject to your guidance, but there's nothing that we're going to get out of this engagement. What's the feeling of members? Let me give you an opportunity, then I'll give the minister the last chance.
Sihlalo, if I may.
Yeah, then Mutubatsa will follow.
Ngiyabonga, Sihlalo. I agree with you. I think we've exhausted all means with HPCSA. They must go back and review this case and the various other cases that we've raised in this portfolio committee, but particularly that one of Dr. Tlaleng Mofokeng. They must review it, and we can even give them 14 days. This is concoction at its highest level. And it's so sad that after everything they've done, after all the findings, after all the punitive measures they've instituted, they can't defend a single action of theirs. Honestly, as an entity, they must hide their heads in shame. And I truly hope that when they come back to us after their review of this case, it will come with consequence management. Heads must roll. Gege, you can't subject our nation to this. You cannot subject us to this. In full view of the country, in full view of the world, you have dropped the ball and embarrassed us. And also, you have done a very horrible thing and set a very wrong precedent, especially when we are having conversations around the positionality of Black health practitioners in the country right now across the entities in the NTOH. This is not a laughing matter. It's not a simple matter. And you will really have to pick up your socks and come back with something tangible. My recommendation, Chairperson, within 14 days, we know the responses to the questions we asked. All of them are embarrassing. They don't have jurisdiction to penalize and punish Dr. Tlaleng Mofokeng. She's a UN rapporteur with immunities. They don't have the jurisdiction to do that. So from the onset, pursuing this case was illegal. From the onset, that's the matter of the fact. So we're giving them an opportunity to find their own mistakes because we don't want to say it overtly. We want them to introspect and come back with retrospection and give us a solution to how they're going to resolve this mess that they've put all of us in now, in the interest of an Israel lobby group. They really must go back and hide their heads in shame. President, inkulu endabeni yenzile la. Inkulu. And you can't even exempt yourself because no, we're talking to an institution, not individuals. And had you not been in a position to justify it, knowing that you're coming to the portfolio committee, you should have done the necessary work to look through what was the previous engagements and give us tangible answers to take with us, and not what we've witnessed today. Never in the history have I ever witnessed something or this delegation to this extent. It's honestly unacceptable. Totally. Ngiyabonga Sihlalo.
Yes, Honorable Mutuvats, allow me to allow Honorable Van Staden. You're going to come after him. He has not spoken. Yeah. Honorable Van Staden.
No, thank you, Chair. It's clear that we're not going to get any answers here tonight. I want to support the suggestion that we give the entity the 14 days to get the things in order and to come back to us. I want also to suggest that it be a physical meeting, and if I do not come with substantial evidence to us or information, or they don't pitch up in the 14 days, then we enforce Rule 167, as you have said. Thank you, Chair.
For that, Honorable Mutuvats.
Yeah, no, I think Dr. Zola Square must be turning in his grave. That's all that I can say. I mean, I want to follow on what the Honorable Shiro was saying. I think this leadership must be turning, must actually hang their head in shame. In particular, within the morass that we find ourselves in as a country. It's a disappointment, and I don't know what to say. I don't have words, you know. The only thing that I can say that Dr. Zola Square must be turning in his grave. I think I agree with honorable members. 14 days. Let's get the answers that we need. Failing which, we must invoke the prescripts of the law. Thanks, Chairperson.
Before Dr. Litlape, over to
You,
you.
Chair. I just wanted to modify what Honorable Van Staden has put on the table, that the 14 days before responses, but since we are in recess and we have a pending trip, it should be, the physical meeting should be one of the meetings that we prioritize when we come back from recess. But the responses must come within the 14 days. And I would also want to urge and ask that when they come back, they bring us information about there's this that has come up as a pandemic, even amongst us as parliamentarians, where people are appointed to structures, but they are full-time employees of the state, and they are not supposed to collect fees from those structures. The logistic arrangements, transport, etc., can be paid for them. So we would want a report from council in terms of that aspect, that from the 12 boards and from council itself, they do an audit about whether people that sit on those structures that are full-time employees of the state are not double dipping in violation of the rules from Treasury and state rules. So I'd like them to provide that information as well within that period that they report back to us. Thank you, Chair.
I've raised the case of Mr. Twala and Mr. Nzise as well. That should be packaged in those responses. Minister, your parting words before I close this meeting. Mr. Minister?
Yeah, no, Chairperson, I've got nothing to add. I agree with the conclusions of the committee and the way forward. I will also try before that meeting to go and meet with the council as I promised. Perhaps by the time we come, some of the issues might have been improved. If there's any improvement to be made, I'll try that. But let's meet openly in a meeting, because the council really needs some serious panel beating and reconstruction. Thank you very much.
My last words to the president and the deputy. You are a successor in title. When you are a successor in title, you inherit the good and the bad. So I don't really envy being in your positions, because I only see the bad that you have inherited. But the appointment that we made, I think the minister, when he did that, he had confidence in you that you'll turn around the situation. So I won't give you a last opportunity. I think you've heard our attitude. What is very important is to go back and crack the whip, demand accountability. We've raised issues. And registrar, if you didn't hear our issues, you're at liberty to liaise with our committee secretary. But this time, malicious compliance like what has been done, because I'll mention there were officials who were in this meeting, maybe to assist you. Miss Melissa de Graaf, she was in the last meeting that we were in. And then Mr. Mamech, he's still here today. He was in our last meeting. So also, these are the issues that you will have to get feedback from them. Because honestly, we just feel we are being disrespected. Yeah, that's basic. And I don't even want to go to the details when I initially sent a message. Your secretary registrar was quick to tell us that you are not available. And in principle, in basic administration, you first attend to your external stakeholders. And then when you are being called by a committee of parliament, we are an oversight body and you are a creature. I think I've mentioned this several times. So there's no need to say that you give us excuses that you are in a retreat. Like I said earlier, you have gone to a retreat. I thought we were going to get something better. It's either they withheld information to you, President, and the councillors of our engagement with them in November. And because the certain issues we raised, coming as they are, so these are some of the issues that so I'll have to close this meeting on this note with that message to you, to say, I hope you are going to do better in future. And within the next 14 days, definitely we are going to prioritize you when we come from recess. We are going to start with you. We are going to start with you. You are coming back again. And then Honorable Van Staden has already proposed a way forward. That's why I say, President, the Deputy President, and the colleagues, I do sympathize with you. Unfortunately, this is a written institution that you have inherited. You've got a responsibility to fix it. That's my parting shot. And I want to thank all the attendees of this meeting, the officials from the department, yourself, President, and the councillor, and the fellow colleagues, and our support staff, including our guest people who have got interest in the work that we are doing. I see they are here in the meeting. Let me thank you, honorable members, for this time. And then till we meet again, enjoy the rest of your evening. I don't know whether it's an evening or it's morning.
It's about to be morning, Chair. Thank you very much and goodbye.
Yes, Minister. I don't think that's how you want to work, eh?
No, definitely not.
You need to do something about it.
Good night, Slalo. Siyabonga.
Thank you.
Bye.
Thank you, Chair.
We have become the new ad hoc committee.
Yeah.